Alright, I made a video earlier and people were wanting clarification and wanted me to slow down a little bit so they could understand what I was attempting to convey to them. And we're talking about holding public officials accountable. Alright? And if Facebook leaves this up, it would be a miracle. I highly doubt they will, but we'll try it. So they asked me to slow down a little bit. So here's what we're going to do. We're going to run through how to hold public officials accountable. I'm going to show you a plethora of information that by the end of it, you should fully be cognizant and comprehend what's actually going on. All public officials after the Reorganization Act of 1871 are required to take this oath right here. This is their private, for-profit oath of office. Okay? Title V, United States Code, subsection 3331, oath of office. They're all required to have it. An individual, except for the president takes a different oath, elected or appointed. All right? Your governor appoints judges. The governor appoints different people. Then you've got the city officials who are elected. You got the county board who's elected, all right, or people that are appointed, city clerks, things of that nature. Okay, so an individual required to take this oath right here, whether elected or appointed to an office of honor, or we got an audible here, profit. Remember when I told you after the Reorganization Act of 1871, this became the new oath because they're engaged in profit in the civil services or uniformed services. Shall take the following oath. I, full legal name. That's first, middle, and last name. Do solemnly swear, and if it's against their religious beliefs, under the First Amendment, to swear, they may affirm. Okay? An affirmation or asseveration. That I will support and defend the Constitution of the United States against all enemies, foreign and domestic. That I will bear true faith and allegiance to the same. That I will take this obligation freely, meaning of their own free will and volition. They weren't under any threat, duress, coercion, vietus arms, or otherwise, without any mental reservations or purpose of evasion, meaning that they're not entering into this under the auspice that they're devising a scheme or an artifice to evade their duty. And that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God is not a prerequisite to doing the affirmation or to swearing in. It's optional. So this doesn't have to be there. This is the oath that public officials have to take under the Reorganization Act of 1871 because they are in it as an office of honor and profit, administering the bankruptcy. They have to have this oath. I'll tell you right now, it's very rare that I ever find anybody that actually has this proper. And if they do have it proper, they fuck up here. Title V, United States Code 3332, Officer Affidavit. No consideration paid for appointment. This could also be attributed to the anti-bribery statement, where they launched an affidavit saying they weren't bribed by anybody. They didn't make any promises to anybody. They didn't accept any gifts or gratuity from anybody or anything like that. Promises weren't made to them. They didn't make promises to anybody. And they're going to faithfully execute their oath. Okay? Oath is something for life. An officer, within 30 days after the effective date of his appointment. So the tolling of time starts after the effective date of his appointment. After he's taken the oath, he's got 30 days, or she's got 30 days, shall file with the oath, which means it needs to be allonged to the oath, what? An affidavit of no consideration paid for appointment. Okay, the anti-bribery statement. Shall file with the oath of office required by section 3331. It's a requirement. They don't get to dodge it because they say, oh, well, I'm an affiliate of the state. I don't have to do this. Bullshit. They hold the position of trust and office of honor, and they're engaged in privateering, profit, gain, okay, for their principal. The state of is not the same as, the state of Arizona is not the same as Arizona. They are two very distinct jurisdictions. One is de facto, one is de jure. Okay, Arizona is de jure. It's a reservation. It's a member of the Union of States. It's the republic guaranteed in the Constitution, and the state of is a bankrupt, defunct, de facto organization that is foreign to the United States of America. It is a subsidiary corporation of the parent corporation known as the United States. Okay, so the United States of America and the United States are two distinguished jurisdictions. They are very different. Okay, just like Arizona and the state of Arizona are very different. Required in section 3331 of this title, an affidavit that neither he nor anyone acting in his behalf has given, transferred, promised, or paid any consideration for or in the expectation or hope of receiving assistance in securing the appointment. In other words, the anti-bribery statement and affidavit that goes along with the Title V, United States Code 3331, Oath of Office. If they don't have these together, filed within the 30 days of their appointment, the office is vacant. All their orders, rules, and regulations are void in ab initio from the beginning because they didn't follow the process for which would have filled the office or the seat of office. All right? I've never seen any public official have any of this, by the way. And I go through a lot of public officials. Title V, United States Code 3333. Employee affidavit. They're telling you what they are. They're employees of a subsidiary corporation administering a bankruptcy under Chapter 11. Loyalty and striking against the government. All right? A, except as provided by subsection B of this section, an individual who accepts office or employment in the government of the United States, remember, they're operating subsidiary corporations under the parent corporation, which is the United States, which is in Chapter 11 bankruptcy and defunct and default, all right, and insolvent, or in the government of the District of Columbia. Okay, the District of Columbia. You're going to have that 10 square mile area, right? The District of Columbia is single and separate and clearly distinct in jurisdictions, not only in the Constitution, but from the Union of States, okay? The Union of States that formed a more perfect union, forming the United States of America, is different than the District of Columbia, Washington, D.C. Shall execute an affidavit within 60 days after accepting the office or employment that his acceptance and holding of the office or employment does not or will not violate sections 7311 of this title. The affidavit is prima facie evidence. Where else have we heard prima facie evidence? Well, statutes, codes, city ordinances, rules, and regulations so often are prima facie evidence of the law. They stand as law until they're rebutted or rebuked. That's what prima facie evidence is. Okay? It looks like law, it sounds like law, it might be law. If nobody disagrees, then it is the law. But it's a rebuttable presumption. With prima facie evidence, it's a rebuttable presumption that the acceptance and holding of office or employment by the affiant does not or will not violate section 7311 of this title. Okay? It's So now we got to go look and see what 7311 of this title is. 7311 of this title is the loyalty and striking. Okay, this again leads to the anti-bribery statement that needs to be allonged to the affidavit, the oath of office, and the Title V 3333 document that needs to be filed within 60 days. An individual may not accept or hold position in the government of the United States or the government of the District of Columbia if he advocates the overthrow of the constitutional form of government. What is the constitutional form of government? Guaranteed republic. So everybody out there on the public forums, on the news media telling you our constitutional democracy is showing their ass because it's a constitutional Republican form of government we've been guaranteed. And they keep talking about their democracy, trying to brainwash you. Is a member of an organization that he knows advocates the overthrow of our constitutional form of government. This right here stops all bar members from being members of the government because under the Senate House Judicial Committee review in 1950, they had a disinterested third party look into the Bar Association and the American Bar Association, and they deemed it to be a communist party hell-bent on utilizing the Communist Manifesto to overthrow our Republican form of government guaranteed by the Constitution. That's why you keep hearing all this democracy horse shit. When you go through the Constitution, you'll never find anything that talks about democracy, okay? Because that was never the intent. 3, participates in a strike or asserts the rights to strike against the government of the United States or the government of the District of Columbia. Or 4, is a member of an organization of employees of the government of the United States or of individuals employed by the government of the District of Columbia that knows, asserts the right to strike against the government of the United States or the government of the District of Columbia. All right? I got to go back. So now we understand what Section 7311 of this title is. All right? Employee affidavit, loyalty, and striking against the government. They're forbidden from doing this. And they have to have the Title V 3331 oath of office and the affidavit and the anti-bribery statement under Title V, United States Code 3332, and it must be compliant under Title V, United States Code 3333. I've never found any public officials that have this, ever. B, an affidavit is not required from an individual employed by the government of the United States or the government of the District of Columbia for less than 60 days for sudden emergency work involving the loss of a human life or the destruction of property. This subsection does not relieve an individual from liability for violation of Section 7311 of this title. All right, so if there's extenuating circumstances, they can overlook the 60 days. But it's still, equity imputes an intention to fulfill an obligation. They're still bound by Title V, Section 7311. Now remember, the Title V 3331 oath of office is the oath for profit and gain in civil services or uniformed services, okay? And for offices of honor. That covers Title V 3331. Your police officers don't have this. Your sheriff don't have it. Your local city officials don't have it. Your county board doesn't have it. All these officials are required to have this, all right? Because they're operating a private, for-profit, ad hoc corporation masquerading around as government. And they're required to have this oath because they're engaged for-profit in civil services, all right? And it's an office of honor, and it's a uniformed service. Then we go here. Every state legislator has its own version of the Constitution. All right? This here happens to be the one for Nebraska. It's under Nebraska Revised Statute 11-101. all these public officials have to have this oath of office as well. Verbatim. All right? Verbatim. With the exception of so help me God, which is not a prerequisite to taking an affirmation or swearing an oath. When they swear this oath, now we have prima facie evidence that they know the law. Because it says, I, full legal name, first, middle, and last, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Nebraska against all enemies, foreign and domestic. If you'll notice, the Title 53331 for-profit oath of office that they take after the Reorganization Act of 1871 has the exact same language, almost verbatim, with the exception of the fact that they're adding the Nebraska Constitution. That I will bear true faith and allegiance to the same, that I will take this obligation freely, meaning of their own free will and volition, and without mental reservation or for purposes of evasion, and that I will faithfully and impartially perform the duties of the office of, and then it's whatever office they're going to fill. Okay? According to the law. You notice it doesn't say according to statutes. It doesn't say according to revised statutes. It doesn't say according to city ordinances, rules, regulations, proclamations, executive orders. It says according to law. The law is very clear in this nation. It's very clearly laid out. I'm going to show it to you guys. And to the best of my ability. Okay, we can't prejudice anybody for executing their duty to the best of their ability, but they are duty bound to know the law. When they take that oath, motherfucker, I gotcha. They are duty bound to not only know the law, but to uphold the law. All right? And to the best of their ability. And I do further swear that I do not advocate, nor am I a member of any political party or organization that advocates the overthrow of the government of the United States. You notice how this doesn't say the United States of America? It says the United States. They're talking about the District of Columbia. They're swearing an oath and allegiance to a foreign entity that is under Chapter 11 bankruptcy and insolvent. All right? They are relinquishing their state sovereignty and citizenship to work for a foreign entity, all right, for which you are a preferred stockholder in, or of this state by force or violence, and that during such time as I am in this position, I will not advocate nor become a member of any political party or organization that advocates the overthrow of the government of the United States or of this state by force or violence, so help me God. Again, this is a for-profit oath of office, all right? So you might be saying, well, is there an oath of office that isn't for-profit? Is there an oath of office of trust and fealty to the republic for which it stands? Yes. Let me show you that oath. Bam. Title 4, United States Code, subsection 101, oath by members of legislators and officers. Here it is. The Title 4 101 oath is to the flag of the United States of America. Okay? It's the original oath to the original flag. All right? And it says, every member of a state legislator and every executive and judicial officer of a state shall, before he proceeds to execute the duties of his office, take an oath in the following form to wit. Now watch how simplistic this oath is. And you're going to see the difference. I, full legal name, first, middle, and last, do solemnly swear that I will support the Constitution of the United States. It's that simple. That is the organic oath. Now, do you see the difference between the private for-profit oath of office against all enemies, foreign and domestic, yada, yada, yada? That's all after the Reorganization Act of 1871. Okay? Because they're privateering. They're pirates on our land. All right? Washington, D.C., the District of Columbia, is not part of the United States of America. It's not part of the Union of States. It's a foreign entity, and I'm going to prove it to you. Now, I require in a FOIA that they produce this oath of office as well. They never have this either. So they don't legitimately fill the office. Then we go into Title 28. Title 28, United States Code 453, Oaths of Justices and Judges. Now watch this oath, because again, you'll notice how it's similar to the Title 5 3331 Oath of Office. All right? Because after the Reorganization Act of 1871, and even before that, there hasn't been a judge since 1789, because judges, don't rule by way of statute, code, city ordinance, rule, and regulation. All right? Actual judges make their ruling on the facts and the injured parties before them. They don't use statutes, code, city ordinances, rules, and regulations. Statutes, code, city ordinances, rules, and regulations all have penal sums and penal bonds attached to them because they're administering a bankruptcy and they need your credit to create more debt so they can continue to float this fictitious monetary system while they rape, rob, and pillage the American people because we're asleep at the wheel. We're the ones to blame. Title 28, United States Code 453, Oaths of Justices and Judges. Remember, they're administrative law clerks and administrative law judges. They're not actual judges. Each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, first name, middle name, last name. If it's not the first name, middle name, last name, they did not take the oath. Do solemnly swear or affirm that I will administer justice without respect to persons. Okay, well, without respect to persons, that's what they do all day long. They're administering persons, legal creatures that creepeth upon the earth, a figment of their imagination that they created through the legislator. All right? And do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as district court judge, county judge, whatever it may be, under the Constitution and the laws of the United States, so help me God. Okay? Now, when I look at their oaths, a lot of times, the first part will be all capital letters. It'll be I, and then their name. They'll put the first name, middle initial, last name. That's a false and fictitious, unregistered, assumed business name, okay, by an unknown, unidentified, unverifiable agent and agency, all right? When they're using a false and fictitious name, we don't know who the fuck they are. And then it'll say, do solemnly swear in all capital letters. Right there, that invalidates the whole fucking oath. Because as our good friend Ken Scott on here will tell you, the Chicago Styles Manual 2016, page 666, there's laws to grammar, and it tells you specifically that all capital letters says nothing. Okay? So that's the judicial oath. If we're going to disqualify them, which I would highly recommend that you do, we're going to come here to Title 28, United States Code 455, disqualification of justices, judges, or magistrate judges. How are we going to disqualify them? Well, first of all, what they are doing is usurping power otherwise not delegated to them. The Constitution limits the power and constrains the power of the federal government and the state governments to just a very minute amount of power amongst both of them. Okay, both state and federal. But I'm going to show you how you disqualify these judges, because what they're really doing after 1933, after the Reorganization Act, after the Township Ward Maternity Act of 1921, is administering estates. They're creating constructive trusts. They're administering a Chapter 11 bankruptcy on behalf of the office of the President of the United States. They're engaging in mixed war against the Constitution. They're engaging in treason, insurrection, and seditious behavior. All under the guise that what they are doing is legal, and they avoid the lawful aspect of things. They avoid it at all costs. But I'm going to show you how you can drag them back into an Article 3 venue, and you can impeach them. And you can impeach them without taking them into an Article 3 venue. But when you go to get your restitution or the restoration of your rights, you're going to want to go into an Article 3 venue, a court of competent jurisdiction that we in the Republic have forever been guaranteed. No matter what act they pass in the legislation or in the Congress, we are always guaranteed a republic form of government if we are able to keep it. Any justice, judge, or magistrate, judge of the United States, shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Well, this is easy to defeat. They're administering a bankruptcy. They're operating as ministerial law clerks or ministerial administrators for these private for-profit organizations masquerading around as government, having DUNS numbers, EIN, employment identification numbers, ITIN, international tax identification numbers, and TIN, tax identification numbers. All right? They're registered with Duns & Bradstreet. They're registered with SAM.gov. All right? And under the Chevron deference case in 1984, when George Orwell was coming out telling everybody what was going to come in the future, he had a very inquisitive mind. And lo and behold, I don't know that he realized that the Chevron deference case was going to absolutely put permanently in effect for the next 40 years exactly what George Orwell was talking about, where the Congress assembled would very bleak and meagerly lay out some illusion of what might possibly be law, and then the private for-profit organizations were going to turn around and create codes, rules, and regulations and apply them as though they are law. All right? And that's what happened. So the overturning of the Chevron deference cases is huge. Now, I've talked to some attorneys that are like, oh, Derek, you don't know what you're talking about. That only applies federally. That only applies to certain federal agencies. Well, I got news for you. After the Reorganization Act of 1871, everything fell underneath the executive branch. The judiciary, the legislative, it's all under the executive branch. The Congress, after the Reorganization Act of 1871, became the advisors to the office of the President of the United States in administering a bankruptcy under Chapter 11. And the judiciary fell underneath the executive branch because under Executive Order under the executive order by Abe Lincoln, the Congress was ordered to reconvene, even though they had the ability to reconvene under their own authority. Okay, so the Congress then and there became the advisors to the commander-in-chief under the executive branch in Chapter 11 bankruptcy, war powers, military doctrine. All right? When the judiciary sat there with their thumb up their ass, they then and there became the administrators of the bankruptcy on behalf of the commander-in-chief under executive order. So everything is under the executive branch. And that's why they're administering everything under the Administrative Procedures Act. Okay? They've absconded from the Constitution and they've wandered into Article 1, Section 8, Clause 17 venues, military tribunals that are very, very limited in the jurisdiction they have, territorially speaking. So, how might these people have a conflict of interest? Well, let's look at it. He shall also disqualify himself in the following circumstances: where he has a personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceedings. Well, the nature and cause of the proceedings, they're hiding from you. They'll always tell you the cause. They'll never tell you the nature. They'll tell you the cause is some benign statute, code, city ordinance, rule, or regulation that they believe you to be subject to through prima facie evidence or your failure to rebut and rebuke. You know, they're going to say that you're a resident. They're going to say that you knowingly, willingly, and intentionally violated such and such revised statute or code or policy or rule or regulation. Okay? But they'll never tell you the nature. What's the true nature of the beast? The fact that they're administering a bankruptcy and they're trying to use your good credit worthiness and reputation to hypothecate credit into existence to create more debt. That's what they're doing. That's why they're using SF 24, 25, and 25A bonds from the GSA. And then if you're in the federal court, it's 273, 274, and 275. You got warehouse bond, performance bond, bid bond, payment bond, promise to appear bond. All this stuff is because they're administering a bankruptcy and trying to hypothecate your credit into existence so they can use it. All right? So is that a conflict of interest? Sure it is. Are they failing to disclose? Are they denying you due process of law? Absolutely. Are they telling you the true nature and cause of the transaction? Because it's a banking transaction. They're administering a bankruptcy under Chapter 11 bankruptcy. All right? They're profiting from ill-gotten gains, alleging criminal activity when there's no victim. No victim, no crime. If the glove doesn't fit, you must acquit type of thing, right? But let's go further. Number 2, where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. All right, that sometimes happens, and you just simply have to tell them that they must recuse themselves, or you can always fire them. I'm going to show you how you can fire them too. 3, where he has served in government employment and in such capacity participated as counselor, advisor, or material witness concerning the proceeding, or expressed an opinion concerning the merits of the particular case in controversy. Did he previously serve in a role of government employment? More than likely. He was district attorney at some point. Disqualified. 4, he knows that he individually or as a fiduciary. This is huge. Title 28, United States Code 455-4 is absolutely monumental. Because when they take the oath of office, they fill a position of trust. They fill a position of profit. And by taking that oath, they become fiduciary trustees. Fiduciary trustees what? On the de jure side, charged with the duty of upholding the Constitution, the Federalist Papers, the treaties. Okay? They know that they are not supposed to be taking you into Article 1, Section 8, Clause 17 venues, territorial military jurisdiction venues, all right? Military tribunals, which is exactly what they're doing. Or his spouse or minor child residing in his household has a financial interest in the subject matter in controversy or in a party to the proceedings. Now, they always have a financial interest in the matter because old Judgy Poo derives his income from the state treasury, okay? And he gets a kickback on every case that he rules on in favor of the state and oppressing you. So his wife benefits, his offspring benefits, and he benefits. So they all have to recuse themselves because they're all fiduciary fucking trustees. It's that simple. You know, there's not one judge that can sit on a foreclosure case legitimately and rule against you and remove you from your home and foreclose on you, because every last fiduciary trustee, their retirement firm, investment firm, retires and invests in mortgage-backed securities. So when they rule against you in a foreclosure, did they just unjustly enrich themselves? Did they just bolster and benefit their retirement fund? You bet your sweet ass they did. Because their retirement investment firm invests in mortgage-backed securities. It's like 33% of their holdings is in mortgage-backed securities, which means that not one judge throughout the entire fucking place could ever sit on the bench without having a conflict of interest. Does his wife benefit from that? Absolutely. From his unjust enrichment? Yes. Okay? Does his offspring benefit from it? Absolutely. Child support, same thing. Child support is the same thing. His family and his spouse benefit from it. Not to mention Blessings versus Freestone tells you very clearly that child support was instituted to benefit the Treasury and is an incidental benefit that does not constitute a right of an offspring to the parent's income. All right? So it's not a right of the offspring. It was set up to benefit the Treasury, for which these people are working for, and it behooves them to rule against you. Okay? When justice becomes clouded through financial gain and wherewithal and materialistic things, we lose sight of justice. And we end up with tyrants unjustly enriching themselves to live a little higher on the hog at your expense. So you have to learn this stuff so you can hold them accountable. As fiduciaries, they got to recuse themselves. All right, they're fiduciary trustees. They've created a constructive trust. They're hiding behind some benign statute, code, city ordinance, rule, or regulation while hypothecating your credit into existence. When you demand that they bring forward the check in the exemplified case file jacket and they don't, well, then we're going to hit them with a full accounting. We're going to report them to the IRS. We're going to hit them with a full accounting for $30-40 million. And when they fail to produce their accounting, then they stipulate to ours, and the IRS doesn't give a shit so long as everybody stipulated and agreed to what the estate was assessed at, how much value was taken out of the estate. Okay? So now they get it for money laundering, tax evasion, conspiracy, and that's how it works. Because they're fiduciary trustees. And I'm going to show that to you here in a second. I'm going to show you why this works and how it works. Because there's two concurrent jurisdictions running simultaneously. You have the de jure side, we the people, the organic constitution, which they're bound by. And then you have this de facto side that they're operating the Chapter 11 bankruptcy and administering it on behalf of their principal for their benefit, stealing, robbing, raping, plundering, and pillaging from the American people. 5, he or his spouse or a person within the third degree of relationship to either of them or the spouse of such person is a party to the proceeding or an officer, director, or trustee of a party, is acting as a lawyer in the proceeding, is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. 4, is to the judge's knowledge, likely to be a material witness in the proceeding. But again, we just want to focus right here. The fact that they're fiduciary trustees. All right? They can never abscond from that position. They can't walk away from that position. They'll always be trustees of the American people. A judge should inform himself. That means I shouldn't have to tell this shit dick one fucking thing. He should already fucking know. In fact, he's got a duty to know and self-report about his personal and fiduciary financial interests. All right? We're already paying them as trustees and fiduciaries to protect our unalienable rights, our rights to life, liberty, pursuit of happiness, and the enjoyment of property. I shouldn't have to fucking tell him that every time I walk in the fucking room. Capiche? But if they can swindle you, if little short dick over there can fucking swindle you with a menagerie of words and awestruck you by threatening you, issuing threats from the bench, which is unbecoming of a judge, right? That's threat, duress, and coercion via its arms. Now, if you don't stop talking, I put you in jail. Do I not have a right to be heard? Do I not have a right to a fair and meaningful hearing? Not a right to be robbed, raped, looted, plundered, and stolen from? Right? After all, I'm the only man in the building. Everybody else is an agency making profit and gain, enjoying in the folly of piracy on the land. Right? So if anybody has a right to be heard, it's you and nobody else. With the exception that nobody else is pressing a claim against you. Because see, a complaint and a claim are two very different things. Men press claims, corporations file complaints. And make a reasonable effort to inform himself about the personal financial interests of his spouse and minor children residing in the household. This is why no judge can sit on a bench for Title 4D, Title 4A, or Title 4E contracts. Right here. It's perpetual conflict of interest. They're getting a kickback under the American Disabilities Act, Title II and Title III. They're getting financial kickback. All right? Because they're operating underneath the executive branch, which is a violation of the separation of powers, operating as a ministerial administrator, or administrative law judge, or administrative law clerk, administering the rules and procedures that were created by the Bar Association. It's a complete conflict of interest. D. For the purpose of this section, the following words or phrases shall have the meaning indicated. Proceeding includes pretrial, trial, appellate review, or other stages of litigation. So in any stage of this, they can't be involved. They got to recuse themselves. And if they won't recuse themselves, do yourself a favor and fucking fire them. You're fired. 2. The degree of relationship is calculated according to the civil law system. Wait a minute. We're guaranteed one Supreme Court, a court of competent jurisdiction, a court of record, and we are not to be trifled with or bothered unless upon indictment. True bill doing owing. They're supposed to leave you the fuck alone. So all this shit doesn't matter. Fiduciary includes such relationship as executor. They're running around as executor D's on tort. I just told you they're operating in the administrative branch, which means they're administrators under the executive branch. And by taking their oath, they're trustees and fiduciaries. Right here, they're disqualified. I don't know about you, but they damn sure aren't my guardians. They're trustees, administrators, executors, and fiduciaries. Financial interest means ownership of a legal or equitable interest. General tangible, general intangible. However small, doesn't matter if it's for a fucking penny or half a chicken. If they've got any interest at all in the matter, they must recuse themselves. And I'm telling you right now, in almost every situation, they have a financial interest, which is exactly why they're required to file the 1099-R for their retirement. Because every time they rule against we the people, they get a nice little stipend, a kickback, an emoluments violation, or a relationship as director, advisor, or other active participants in the affairs of a party, except that ownership is a mutual or common investment fund that holds securities. Again, they're talking about securities because they're a private, for-profit, ad hoc corporation utilizing the UCC to negotiate negotiable instruments unbeknownst to you because they never provided you due process of law, full disclosure as to the nature and cause of the transaction, which you are rightfully entitled to. See, they don't want to tell you about this because then they got to give up the funds that they're trying to steal as pirates, hypothecating into existence without your knowledge. A financial interest in such securities unless the judge participates in the management of the funds. Yep, that's what they're doing. 2, an office in an educational, religious, charitable, fraternal, or civic organization is not a financial interest in securities held by the organization. And 3, the proprietary interest of a policyholder in a mutual insurance company or of a depositor in a mutual savings association or a similar proprietary interest is a financial interest in the organization only if the outcome of the proceedings could substantially affect the value of the interest. They always have an interest in what they're doing. The clerk of the court's paid by the state. The district attorney is paid by the state. The county attorney is paid by the state. The police officer is paid by the state. The appellate courts are all paid by the state. Even when they fuck you, the money just keeps running up the ladder. All right. So they're more than happy to fuck you without a reach around. 4, ownership of government securities is a financial interest in the issuer only if the outcome of the proceedings could substantially affect the value of the securities. I am the original source value issuer of all issue. When they engaged in identity theft and hijacked my name and my credit worthiness and my reputation, to bring me into a foreign jurisdiction using statutes, codes, city ordinances, rules, and regulations for which I am not subject to. They engaged in piracy on the land, Title 18, 1661. All right? And identity theft. And RICO, Title 18, 1951. All right? They're all engaged in it. They're all doing it. The American people have been buffaloed to sleep and led to believe that these people are honorable. They're anything but fucking honorable. They're thieves. E. No justice, judge, or magistrate judge shall accept from the parties to the proceedings a waiver of any ground for disqualification enumerated in Section B, where the ground for disqualification arises only under Section A. Waiver may be accepted provided it is preceded by the full disclosure on the record of the basis for disqualification. That's really simple. That's really simple. We want to see their Title V 33331 oath of office. We want to see their Title V 33332 affidavit in support. We want to see their Title V 33333 loyalty statement. Okay? We want to see their anti-bribery statement. And guess what? They don't have it. We want to see their SF-61. Nobody within the body politic of alleged government has an SF-61 on record. None of them fill the actual seat or office of government. Everything they are doing is arbitrary and capricious, and they are doing it in their indefeasible, unlimited personal capacity. And they are unjustly enriching themselves while masquerading around as public officials. All right? Masquerading around as officials of the United States government. But they're actually operating private for-profit organizations that have DUNS numbers, cage codes, SAM number, tax identification number, EIN, so on and so forth. I'm going to show it to you here in a second. All right? Again, they're operating in Article 1, Section 8, Clause 17, military tribunal, outside of their territorial jurisdiction, which is 10 square miles. F, notwithstanding the proceedings provisions of this section, if any justice, judge, magistrate judge, or bankruptcy judge, they're all bankruptcy judges, okay? They're all administering tax courts, all right? The statutes, codes, city ordinances, rules, and regulations all have penal sums and penal bonds attached to them, and they're all administering them on the behalf of the Internal Revenue Service as glorified tax courts, excise, impost, and export taxes. Okay? That's what they're doing. But then they're not reporting to the IRS, so they're running off with the funds for their private bar guild, which is a communist manifesto hell-bent on overthrowing the government while screwing the American people. To whom a matter has been assigned would be disqualified after substantial judicial time has been devoted to the matter because of the appearance or discovery after the matter was assigned to him or her that he or she individually or as a fiduciary, remember when they take that oath, they become fiduciary trustee, or his or her spouse or minor child residing in his or her household has a financial interest in a party other than an interest that could be substantially affected by the outcome. Disqualification is not required if the justice, judge, magistrate judge, bankruptcy judge, spouse, or minor child, as the case may be, divest himself or herself of the interest that provides the grounds for the disqualification. Okay? The cliffhanger here is the fact that they're fiduciary trustees. When they took the oath, they became fiduciary trustees. We're going to put them back in that box. Next. Boop. How else are we going to... Okay, so we covered the oaths, right? Title V 3331 oath. We covered the Nebraska Revised Statute 11101 oath. We covered the Title IV United States Code 101 oath. We covered the Title 28 453 judicial oath. Now we need to look into the certificate of the notarial acts, which they never have. They never have these certificates. These certificates must be accompanying their oath, their affidavit, and their statement of loyalty or anti-bribery statement. Let's look and see what it says. Necessity for certification of notarial acts. This is Title 22, Code of Federal Regulations, 92.12, necessity for certification of notarial acts. A notarizing officer must execute a written certificate attesting to the performance of a notarial act. How many of you have ever gotten their fucking oaths and seen a certificate attesting to the performance of the notarial act? Never seen it before in my life. This certificate may be inserted on or appended to the notarized document. See section 9217 regarding the fastening of sheets. The certificate evidence the performance of the notarial act. Failure to execute this certificate renders the notarial act legally ineffective. Legally ineffective. Each notarial act should be evidenced by a separate certificate. Two or more distinct notarial acts should be attested to by one certificate. Should not be attested to by one certificate. So two notarial acts. So you do the oath. That should be a notarial certificate. Then you do the Title 5 333-2 affidavit in support. That should be a separate certificate of a notarial act. Then you do the Title 5 3333 anti-bribery statement and loyalty statement, and that should have its own certificate of validity, okay, of the notarial act. But they never have any of that. This is how you prove all their orders are void. Cockamamie horseshit and bullshit. Title 22 CFR, subsection 9213, form of notarial certificate. The form of notarial certificate depends on the nature of the notarial act it attests. See subsection 9218 to 9248 for disclosure of the various forms of notarial certificates. Rules pertaining to venue's jurisdiction, and signing and sealing are common to all notarial certificates. This is going to grab you by the short and curlies when I get to it. Venue. Remember, venue is jurisdiction. Title 22, Code of Federal Regulations 9214, venue on notarial certificates. 92.14, venue of notarial certificates. The term venue means the place where the certificate is executed. The venue must be shown on all notarial certificates to establish the qualifications and sphere of authority of the notarizing officer to the performance of the notarial act. The items characteristic of a typical venue in the order of their appearance in the certificate are as follows. Name of the country, or dominion, territory, colony, island, as appropriate. All right? So if it's a territory, is it part of the country? No. If it's a territory, it's part of Article 1, Section 8, Clause 17. Federal enclaves, 10 square mile area, the Swaney Islands, the Samoan Islands, Puerto Rico, and Guam. That's territory. And, of course, Article 1, Section 8, Clause 17 speaks about military forts, arsenals, and buildings and land that they own, which isn't much. 2, name of province or major administrative region. Administrative region. If none, this may be omitted. 3, name of local community, city, town, or village. 4, name of foreign service post. This right here is showing you that it's foreign. All right? When a notarial act is performed and the notarial certificate executed at a locality in a consular district other than the locality in which the Foreign Service Office is situated. Other than where the Foreign Service Office is situated, the venue should mention only the name of the country or dominion, territory, colony, island as appropriate, and the name of the consular district. They're telling you that it is a Foreign Service Office situated. The venue used at a foreign service post, which has not been officially designated as an embassy, legation, consulate general, consulate, or consular agency should bear the nation American Consular Service in place of the post name. Title 22 CFR 92.15, signing notarial certificates. Again, any notarial act has to have a notarial certificate or it is legally void. The notarizing officer should sign a notarial certificate on the low right-hand side. The name and full official title of the notarizing officer should by typed, stamped, or with rubber stamp, or printed in the ink on two separate lines immediately below his signature when the notarizing officer is assigned to a foreign service post in both a diplomatic and consular capacity. He should use his consular title in the notarial certificate. Title 22 CFR 92.16, sealing the notarial certificate. All right? Everything's about signatures, marks, and seals. Okay? Subsection 92.16, sealing the notarial certificate. The notarizing officer should seal a notarial certificate with the impression seal of the post on the lower left-hand side of the certificate. A notarial certificate executed at a foreign service post which has not been officially designated as an embassy, legation, consulate general, consulate, or consular agency should be sealed with an impression seal bearing the legend American Consular Service and the name of the locality. Title 22 CFR 92.17, fastening of pages. When the instrument or documents to which a notarial act relates consists of more than one sheet, or when the notarial certificate will be attached and not written on the document itself, the notarizing officer should bring all the sheets comprising the document together under his official seal. So when they're using a notary, it's taking you into a foreign jurisdiction, okay? Title 22 CFR 92.18, oaths and affirmations defined. Oath and affirmation defined. Oath. An oath is an outward pledge. So an oath is an outward pledge given by the person taking it that his attestation or promise is made under an immediate sense of his responsibility to God. In a broader sense, the word oath includes all forms of attestation by which a person signifies that he is bound in conscience to perform and act faithfully and truly, and in this sense, it includes affirmation. Affirmation. An affirmation is a solemn and formal declaration or asseveration in the nature of an oath that a statement or series of statements is true. When an oath is required or authorized by law, an affirmation in lieu thereof may be taken by a person having conscious scruples against taking an oath. As a general rule, an affirmation has the same legal force and effect as an oath. Title 22 CFR 92.19, administering an oath. The usual formal for administering an oath is as follows. The officer administering the oath requests the person taking an oath to raise his right hand while the officer repeats the following words. You do solemnly swear that the statements set forth in this paper, which you have here signed before me, are true. So help you God. Whereupon a person taking oath answers, I do. Title 22 CFR 92.20, administering an affirmation. In administering an affirmation, the procedure followed is generally the same as in the case of an oath, but the formal is varied by the use of the following words. You do solemnly, sincerely, and truly affirm and declare that, and this you do under the pains and penalties of perjury. That's your affirmation. Title 22 CFR subsection 92.21, notarial certificate to oath or affirmation. The written statement attesting to the administration of an oath or affirmation is known as a jurat. All the people out there doing a simple notary statement and acknowledgement on something that they're swearing out to or affirming are fucking up. It's a jurat, okay? The jurat must be signed and sealed by the notarizing officer. See subsection 92.15 and 92.16 on signing and sealing a notarial certificate. Title 22 CFR subsection 92.22, affidavit defined. Affidavit defined. An affidavit is a written declaration under oath made before some person who has the authority to administer oaths without notice to any adverse party that may exist. One test of the sufficiency of an affidavit is whether it is so clear and certain that it will sustain an indictment for perjury. If found to be false, an affidavit differs from a deposition in that it takes ex parte, in that it is taken ex parte and without notice, while a deposition is taken after notice has been furnished to the opposite party, who is given an opportunity to cross-examine the witness. So, an affidavit allows for lying by omission, all right? Meaning that you might fill out an affidavit and omit certain facts that lead people to believe the contrary of what is true, accurate, correct, and not misleading. That's why when you do an affidavit, I like to do testimony in the form of an affidavit and swear out to it or affirm it, okay? And I'm willing to be deposed on the matter, okay? So, until you've been deposed on your affidavit, the affidavit could actually allow lying by omission, which is why you need to be deposed. Title 22 CFR 92.23, taking an affidavit. The notarizing officer taking an affidavit should, A, satisfy himself as far as possible that his notarial act will be acceptable under the laws of the jurisdiction where the affidavit is to be used. B, require the personal appearance of the affiant at the time the affidavit is taken. C, require satisfactory identification of the affiant. And D, administer the oath to the affiant before the affiant signs the affidavit. Title 22 CFR subsection 92.24, usual form of affidavit. Affidavits are usually drawn by competent attorneys or are set out in established forms. The form and substantive requirements of an affidavit depend principally upon the purpose for which it is made and the statutes of the jurisdiction where it is intended to be used. When a notarizing officer finds it necessary in the discharge of his official duties to operate an affidavit, or when he assists a private person in preparing an affidavit, see subsection 92.11b, he should, where possible, consult the pertinent statutory provisions. Title 22 CFR subsection 92.25, title of affidavit. Generally, an affidavit taken for the use in a pending cause must be entitled in that cause so that it will show to what proceedings it is intended to apply, and may support an indictment for perjury in the case it proves to be false. So under the False Claims Act, or creating an act of perjury by falsifying a record under the pains and penalties of perjury. If there is no suit pending at the time the affidavit is taken, or if the affidavit is not to be used in any case in court, no title need be given. Title 22 CFR 92.26, Venue on Affidavit. The venue must always be given and should precede the body of the affidavit. See subsection 92.14 regarding venue on notarial certificate generally. Title 22 CFR subsection 92.27, affiant's allegation in affidavit. Affiant's allegations in affidavit. Substance of allegations. Although a notarizing officer is generally not responsible for the correctness of the form of an affidavit or the manner in which the allegations therein are set forth, see subsection 92.11a, regarding the preparation of legal documents by attorneys, subsection 92.11b, regarding the preparation of legal documents by notarizing officers, and subsection 92.24 regarding the form of an affidavit, he may, in appropriate instances, draw the affiant's attention to the following generally accepted criteria as regards the substance of the allegations. 1. Material facts within the personal knowledge of the affiant should be alleged directly and positively. Facts are not to be inferred where the affiant has it in his power to state them positively and fully. 2. If the matters stated in the affiant's affidavit rest upon information derived from others rather than on facts within his personal knowledge, he should aver that such matter are true to the best of his knowledge and belief. 3. If the allegations made on information and belief are material, the source of the information and grounds of belief should be set out and a good reason given why a positive statement could not be made. 4. If the conclusion of the affiant are drawn from the contents of the document, such contents should be set out or exhibited so that the authority to whom the affidavit is presented may determine whether the affiant's deductions are well-founded. And B, veracity of allegations. Notarizing officers are not required to examine into the truth of the affiant's allegations or to pass upon any continuous questions involved. In many instances, the matter referred to in an affidavit will be of a technical or special nature beyond the officer's general knowledge or experience. However, he may, in certain circumstances, refuse to take an affidavit. See subsection 92.9 regarding the types of situations in which an officer might properly refuse to perform a notarial service. Also see subsection 92.10 regarding the waiver and other statements which may be included in a notarial certificate where evidence existed of a falsity in the affiant's declaration. We're almost done with the whole notary thing. Subsection 22, CFR, Code of Federal Regulations, subsection 92.28, signature of affiant on affidavit. The signature of an affiant is indispensable. The affiant should always sign the affidavit in the presence of a notarizing officer. Subsection 22, CFR 92.29, oath or affirmation to an affidavit. Affidavits made before notarizing officers must be sworn to or affirmed. So see subsection 92.23D. And last but not least, Title 22, CFR 92.30, acknowledgement defined. Acknowledgement defined. An acknowledgement is a proceeding by which a person who has executed an instrument goes before a competent officer or court and declares it to be his act and deed to entitle it to be recorded or to be received in evidence without further proof of execution. An acknowledgement is almost never made under oath and should not be confused with an oath. See subsection 92.18.8 for determination of oath. Moreover, an acknowledgement is not the same as an attestation, the latter being the act of witnessing the execution of an instrument and then signing it as a witness. Instruments requiring acknowledgments generally are those relating to land, such as deeds, mortgages, leases, contracts, and the sale of land, and so on. All right. Title 8, United States Code, subsection 1481, loss of nationality by native born or naturalized citizen, voluntary action, burden of proof, presumptions. A person who is a national of the United States, whether by birth or naturalization, shall lose his nationality by voluntarily performing any of the following acts with the intention of relinquishing United States nationality: obtaining naturalization in a foreign state. Okay, the District of Columbia is a foreign state. The United States is a foreign state. The state of is a foreign state. Anybody taking an oath is taking an oath to a foreign principal or a foreign state upon his own application or upon an application filed by a duly authorized agent after having attained the age of 18 years, or taking an oath or making an affirmation or other formal declaration of allegiance to a foreign state or a political subdivision thereof, having attained the age of 18 years, or entering or serving in the armed forces of a foreign state if such armed forces are engaged in hostilities against the United States, or such persons serve as a commissioned or non-commissioned officer, or accepting, serving in, or performing the duties of any office, post, or employment under the government of a foreign state or a political subdivision thereof, after attaining the age of 18 years, if he has or acquires the nationality of such foreign state, or accepting, serving in, or performing the duties of any office, post, or employment under the government of a foreign state or a political subdivision thereof, after attaining the ages of 18 years of age, for which office, post, or employment an oath, affirmation, or declaration of allegiance is required, or making a formal renunciation of nationality before a diplomatic or a consular officer of the United States in a foreign state in such form as may be prescribed by the Secretary of State. Okay? So in other words, when they take their oath of office, they are foreign agents. Okay? And that's why we look at Title 22, United States Code, subsection 612, registration statements. Filing contents. No person shall act as an agent of a foreign principal unless he has filed with the Attorney General a true and complete registration statement. This is the Rule 2 opinion letter and his registration statement. Okay, they're all responsible for doing this once they take an oath. And supplements thereto as required by subsection A and B of this section, or unless he is exempt from registration under the provisions of this subchapter, except as hereinafter provided. Every person who becomes an agent of a foreign principal shall within 10 days thereafter, 10 days, file with the Attorney General in duplicate a registration statement under oath on a form prescribed by the Attorney General. The obligation of the agent of a foreign principal to file the registration statement shall, after the 10 days of his becoming such agent, continue from the day to day, and termination of such status shall not relieve such agent from his obligation to file a registration statement for the period during which he was an agent of a foreign principal. The registration statement shall include the following, which shall be regarded as material for the purpose of this subchapter. Okay? They go into all these documentations they're supposed to file. So, I've already shown you that if they take the oath, the Title 5 3331 oath, if they take the revised statute oath, if they take the Title 4 oath, if they take the Title 28 oath, okay, they've got the proper documentation through the certificates for the notary certificates and seals, all right? And by taking that oath, they become foreign. And this affirms that they're foreign under Title 22, which is really the Foreign Registration Act of 1938 as amended in 1939. All right? Now, if you don't believe me at this point that they're fucking foreign, let me just show you. What do we have here? The state of Indiana, Great Seal. Okay, this is its register number. Here's the application number. The registrant is the United States of America, and it's registered in Canada. Anybody operating under the Great State Seal of Indiana is a foreign agent because they're operating under a seal that's registered in Canada. Okay, if that's not enough for you, hold on. Let's pull out this one. Department of Defense, DOD. Registered where? Canada. Anybody operating under this signet and seal is a foreign agent foreign to the United States of America. How do we prove it? Well, the registrant is the United States of America. Okay? Here is the application number. And where is it registered again? Canada. Oh, that's not enough for you? Hold on, let me pull up another one. Maybe you don't fucking quite believe me yet. District of Columbia. It's Great State Seal, right? Or it's Great Seal for its sovereign city, state, nation that they have going on. Well, all be damned. Who's the registrant? The United States of America. What's the application number? It's right there. All right? And where is it registered again? Canada. Still don't believe me? Here's the United States Secret Service. Registered where? Canada. Here's their number. And who registered it? United States of America. Anybody operating under that is required under Title 22, 612 to register as a foreign agent. Oh shit. We've all seen this one before, right? Sonic Eagle Design 1799441. Okay, where's it registered at again? Canada. It's a trademark up in Canada, being used in the United States of America, but it's foreign. Who registered it? Ah, shit. The United States Postal Service, 475 Plaza, Washington, D.C., District of Columbia, United States of America. All right? Where's the number at for the application? Right there. And again, where's it registered? Canada. Anybody operating underneath that signet and seal, guess what? Is a foreign agent. Now, just because I know many of you don't understand what the fuck I'm talking about, maybe you think I've lost my fucking rocker. And after 15 years of doing 16 to 18 hour days of studying day and fucking night to be able to articulate this to you guys, let me just show you the truth. Let me just show you the truth. We're going to slide this over a little bit. Let's see, how can I do this? Push this back, slide that over there. Okay, here we go. You ready? Great Seal of Ohio, right here, registered in Canada. The Great Seal of Mississippi, registered in Canada. The Great Seal of Pennsylvania, registered in Canada. The United States Secret Service, registered in Canada. The Seal of the State of Washington and Design, registered in Canada. The Great Seal of the State of California, registered in Canada. The Department of the Treasury Design, registered in Canada. Their signature and seal is registered in Canada. They're foreign. The State of Texas, registered in Canada. Anybody operating under the Great Seal of Texas is a foreign agent operating on behalf of a foreign principal, and their signet and seal is registered in a foreign land. The Library of Congress Design, guess what? Registered in Canada. Young Astronauts and Circle Design, registered in Canada. The Great Seal of the State of New York Design, registered in Canada. The Seal of the State of Arkansas, registered in Canada. The Great Seal of the United States and Design, where's it at? That's right, registered in Canada. The Great Seal of the State of Utah, registered in Canada. Small Business Administration and Design, registered in Canada. The Seal of the State of Indiana, registered in Canada. The Great Seal of the State of Nevada, registered in Canada. I can go on for days. The Great Seal of the State of New Jersey, registered in Canada. The Seal of the State of New Hampshire, registered in Canada. The State of Oregon, registered in Canada. Whoops. Oop. Go back. There we go. The State of Oregon, registered in Canada. The Great Seal of the State of Tennessee, registered in Canada. The Great Seal of the State of Minnesota, registered in Canada. Anybody operating under these seals that I'm telling you about are foreign agents operating on behalf of a foreign principal. Remember, the Attorney General in Black's Law Dictionary is the Esquire for the Crown, the British Crown. All right? The Great Seal of the State of Missouri, registered in Canada. Why do you think all these great seals are registered up in Canada? That's right, you didn't win the fucking War of 1812. All right? The Great Seal of the State of Montana, registered in fucking Canada. All right? Hold on. If that ain't enough fucking proof for you, let's keep going. Why not? I'm fucking having a ball here, right? The Great Seal of the State of Nebraska, registered in Canada. The Administrative Offices of the United States Courts and Design, registered in Canada. The Agency for Volunteer Services, Actions and Design, registered in Canada. The Great Seal of the State of North Carolina, registered in Canada. The Great Seal of the State of Wisconsin, registered in Canada. Again, anybody operating under these great state seals that are registered in fucking Canada are operating on behalf of a foreign principal registered in a foreign country. Department of the Navy, United States of America Design. Anybody operating underneath that logo, under that signet and seal, is a foreign fucking agent. Great Seal of the State of Idaho, registered in Canada. Great Seal of the State of Michigan, registered in Canada. Great Seal of the State of Iowa, registered in Canada. The Department of the Navy, United States Marine Corps, registered in Canada. The State of Colorado, registered in Canada. The Department of Army and Design, registered in Canada. The U.S. Department of Interior Design, registered in Canada. The Great Seal of the State of Arizona, registered in Canada. Board of Governors of the Federal Reserve System and Design, registered in Canada. Department of Defense, registered in Canada. The Great Seal of Maryland, registered in Canada. The Department of the Air Force, registered in Canada. The Seal of the Speaker, United States House of Representatives and Design, registered in Canada. Export and Import Bank of the United States, registered in Canada. Great Seal of the United States of Kansas, registered in Canada. Seal of the United States Copyright Office, registered in Canada. United States of America Department of Transportation and Design, registered in Canada. Department of Labor, United States of America, registered in Canada. Great Seal of the State of New Mexico, registered in Canada. Department of Energy, United States of America, registered in fucking Canada. Seal of the State of Illinois, registered in Canada. National Capital Planning Commission and Design, registered in fucking Canada. Partnership to Fuel America, registered in Canada. Great Seal of the State of Florida, registered in Canada. Great Seal of the State of North Dakota, registered in Canada. Again, anybody operating under these signets and seals is a foreign agent operating on behalf of a foreign principal that is registered in a foreign country. State of South Dakota, Great Seal, registered in Canada. Seal of the State of Rhode Island, registered in Canada. Great Seal of the State of Wyoming, registered in Canada. E Pluribus Unum and Design, registered in fucking Canada. Singular Republica, Massachusetts, registered in Canada. Alabama Great Seal, registered in Canada. American Battle Monuments Commission and Design, registered in fucking Canada. District of Columbia, registered in Canada. Fountain of Youth Technologies. Oh, that one's of no consequence. Great Seal of the State of Oklahoma, registered in Canada. United States Department of Agriculture and Design, registered in Canada. Anybody operating under these signets and seals, again, is a foreign agent operating on behalf of a foreign principal and is required under Title 22, 612, 611, 613, and 614 to report to the Attorney General as a foreign agent with their Rule of Two opinion letter from the IRS. Federal Mediation and Coalition Services and Design, registered in Canada. National Mediation Board and Design, registered in Canada. National Labor Relations Board and Design, registered in Canada. United States Postal Service Design, registered in fucking Canada. Home Loan and Bank Board and Design, registered in Canada. United States Civil Service Commission, registered in Canada. State of Georgia, registered in Canada. Securities and Exchange Commission, registered in fucking Canada. Sigillum Republic, Connecticut, registered in Canada. Railroad Retirement Board, USA and Design, registered in fucking Canada. South Carolina, registered in Canada. United States Coast Guard, registered in Canada. USAVE Auto Rental American Design, registered in Canada. Interstate Commerce Commission Design, registered in Canada. Federal Communications Commission Design, registered in Canada. Great Seal of the State of Delaware, registered in Canada. Federal Trade Commission, United States of America, registered in Canada. U.S. Department of Housing and Urban Development, registered in fucking Canada. SSS Design, registered in Canada. Consumer Production Safety Commission and Design, registered in Canada. United States International Trade Commission and Design, registered in Canada. American Resolution Bicentennial Design, registered in Canada. Federal Maritime Commission Design, registered in Canada. National Credit Administration, registered in Canada. Energy Research and Development Administration, registered in Canada. United States of America Government Printing Office, registered in Canada. General Service Administration, registered in Canada. Federal Power Commission and Design, registered in Canada. Department of Justice and Design, registered in Canada. National Design, nope, that's not one. State of Louisiana, Great State Seal, registered in Canada. Civil Aeronautics Board and Design, registered in Canada. Anyway, I think you guys are starting to get my point. Farm Credit Administration, registered in Canada. All right? I hope you guys are picking up what I'm laying down. They're all foreign actors, owing a foreign allegiance. Veterans Administration, registered in Canada. State of West Virginia, registered in Canada. Maine, registered in Canada. Cost Accounting Standard Board, registered in Canada. State of Hawaii, registered in Canada. Department of Health, Education, and Welfare, United States of America, registered in Canada. Virgin and Virginia, registered in Canada. The Great State Seal. So anyway, just wanted to make that point. So if there's any doubt as to what I'm telling you, I hope that I have removed that doubt at this point. So, remember, their oath of office says that they can't interact with any foreign principal that is hell-bent on destroying or overthrowing the form of government, the Republican form of government guaranteed. Well, let me just show you this little nifty thing here. Union Calendar number 1078, 81st Congress, 2D session, House Report number 3123, report on the National Lawyers Guild legal bulwark of the Communist Party. September 17, 1950, original release date. September 21st, 1950, committed to the Committee of the Whole House on the State of the Union and ordered to be printed. Prepared and released by the Committee on the Un-American Activities, U.S. House of Representatives, Washington, D.C., District of Columbia. Committee on an Un-American Activities, U.S. House of Representatives, 81st Congress, 2nd edition. All right? So, Union Calendar number 1078, 81st Congress, 2nd edition, House of Representatives, report number 3123, report of the National Lawyers Guild, legal bulwark of the Communist Party, September 21st, 1950, committed to the Committee of the Whole House on the State of the Union and ordered to be printed. Mr. Wood, from the Committee of Un-American Activities, submitted the following report. Pursuant to House Resolution 5, 79th Congress, first session, the National Lawyer Guild is the foremost legal bulwark of the Communist Party. Its front organizations and controlled unions, since its inception, it has never failed to rally to the legal defense of the Communist Party and individual members thereof, including known espionage agents. It has consistently fought against national, state, and local legislation aimed at curbing the communist conspiracy. It has been most articulate in its attack upon all agencies of the government seeking to expose or prosecute the subversive activities of the communist network, including national, state, and local investigative committees, the Department of Justice, the FBI, and law enforcement agencies generally. Through its affiliations with the International Associations of Democratic Lawyers and International Communist Front Organization, the National Lawyers Guild, has constituted itself an agent of a foreign principal hostile to the interest of the United States. It has gone far afield to oppose the foreign policies of the United States in line with the current line of the Soviet Union. These aims, the real aims of the National Lawyers Guild, as demonstrated conclusively by its activities for the past 13 years of its existence, are not specified in its constitution or statement of avowed purpose. In order to attract non-communists to serve as a cover for its actual purpose as an appendage to the Communist Party, the National Lawyers Guild poses benevolently as a professional organization which shall function as an effective social force in the services of the people, to the end that human rights shall be regarded as more sacred than property rights. In the entire history of the Guild, there is no record of its ever having condemned such instances of the violation of human rights as founded in the Soviet slave labor camps and in the series of Moscow trials which shocked the civilized world. The National Lawyers Guild was formally organized at a convention held in the Washington Hotel in Washington, D.C. on February 19th through the 22nd in 1937. National headquarters were established in the nation's capital, where they remain today. Communists publicly held the founding of the National Lawyers Guild. New Masses, a weekly publication of the Communist Party, featured an article entitled Defense for the Council, the Need for the National Lawyers Guild, in its issue of June 14th, 1938, page 19 through 21. This article, written by Charles Retsch, an attorney for the Soviet government and a member of the Guild, observed that with the growth of the American Labor Party in New York and kindred progressive movements throughout the United States, the lawyers, who in many of the smaller communities are the nerve center of political activities, will be an invaluable aid in galvanizing the latent liberal elements of the country into a political force. The National Lawyers Guild can and will form one of the most important adjuncts to the progressive movement, representing the interests of the workers and farmers. The International Labor Defense, which was cited by former Attorney General Francis Biddle as the legal arm of the Communist Party, also enthusiastically welcomed the new front, the National Lawyers Guild. The ILD stated in its 1936 through 37 yearbook that the emergence of the National Lawyers Guild is regarded by the International Labor Defense as a heartening expression of the devotion of thousands of American attorneys to the American principle of democracy, not a republic, and a concrete step on their part in the struggle to maintain and enlarge democratic rights. Page 64, Earl Broder, testifying before the House Committee on Un-American Activities on September 6, 1939, in his capacity as General Secretary of the Communist Party, admitted that the National Lawyers Guild was a communist transmission belt. This has been corroborated by Louis F. Budzen, former member of the National Committee of the Communist Party and one-time managing editor of its official newspaper, The Daily Worker. Testifying before the House Committee on Un-American Activities on April 3, 1946, Mr. Budzen described the National Lawyers Guild as a working ally of a Communist Party and stated that members of the Guild would be under the influence of a party while officers would be communist or fellow travelers. Testifying again before the committee on July 20th, 1948, Mr. Bunn said, in the National Lawyers Guild, there is a complete duplicate of the Communist Party's hopes and aspirations in that field, although there are a number of non-communists in the National Lawyers Guild. In fact, some of their lawyers locally are not communists, but they play the communist game either wittingly or unwittingly. So this is a 53-page document. I'm not going to read through it all, but wanted to point that out to you, just so you know that the Lawyers Guild and the bulwark of the Bar Association, the American Bar Association, are a part of the Communist Party, hell-bent on overthrowing the constitutional republic that has been guaranteed. Title 8, United States Code, subsection 1481A2, taking an oath or making an affirmation or an oath, formal declaration of allegiance to a foreign state or a political subdivision thereof. What must a judge, administrator, trustee, attorney give up to hold office? Title 8 United States Code 1481 stated once an oath is taken, citizenship is relinquished. So once they take the oath, which is to the United States or the United Nations, because remember in 1945, the United States, all the seats of government were granted over to the United Nations. They are not considered American citizens anymore by becoming a foreign entity agency of a state. This would explain why all your senators and politicians have dual citizenship with Israel as well, all right, which is a violation of the Constitution because they've pledged an oath to a foreign entity. Challenges to the judge, universal to all cases. A judge who refuses our law is loyal to some other authority. Ask the judge if he or she is a member of the State Bar Association. If so, challenge the judge under Title 22 USC 611 as a foreign agent. All judges are lawfully required by Title 28 United States Code 453 to have an oath of office. Ask the judge if he or she has an oath of office. If yes, accept the oath of office in admiralty jurisdiction. Now the judge is subject to the criminal prosecution and civil litigation for any injury he or she may cause you. If no, the attorney is not a judge and has no lawful authority to proceed. Your state representative should be informed by petition for impeachment of the judge. Present the facts of the case. The law is not necessary. Have it notarized and send it by certified mail. As we remove the unlawful judges, lawful judges will take their place. There are sanctions against officials who even violate common law constitutional oaths. Title 18 USC 1621, reference to U.S. courts. There are no judicial courts in America, and there has not been since 1789. Judges do not enforce statutes and codes. Executive administrators enforce statutes and codes as administrative law judges or administrative law clerks. There have not been any judges in America since 1789. There have just been administrators. FRC versus GE 281 US 464, Keller versus PE 261 US 428, 1 Stat 138-178. Whereas the state is a corporation, not an injured party with affidavit. This applies both with federal rules of evidence and state rules of evidence. There must be a competent first-hand witness, a body, okay? There has to be a real person making a complaint and bringing evidence before the court. Corporations are paper and can't testify. Manifestly, such statements cannot be properly considered by us in the deposition, of a case. United States versus Lavasco, 431 U.S. 783 97 S period CT period 2044, 52 L period ED period 2D 752 06 09 1977, referring to the Utah judge caught practicing law without a license, now a nominee for federal judicial office. What's strange about this case is that there is no such thing as a license to practice law. They are admitted into practice. Who issues them a license? The bar. As per the United States Supreme Court, the practice of law cannot be licensed by any state. Schwer versus Board of Examiners, 353 U.S. 238, 239. The practice of law is an occupation of common right. Sims versus Ahern's, 271 S period W period 720, 1925. So, now let's get into the good stuff. We've already covered how they're foreign, how the fiduciary trustees, they got to remove themselves, they've got a conflict of interest, and now we're going to show you how to really disqualify them in a deeper fashion, because another gentleman didn't understand what I was talking about, so he was asking me, can you please redo this slower in a little more detail? So I will do it a little slower. All right, first of all, under Title 26, okay, United States Code, we're dealing with the IRS, the IRM, the Internal Revenue Code, the Internal Revenue Manual, the Title 26. Under Title 26, 6903, Notice of Fiduciary Relationship. Remember earlier, I told you they couldn't sit up there on that bench because they're a fiduciary. Rights and obligations of a fiduciary. Upon notice to the Secretary. Secretary of who? Secretary of what? They're vague and ambiguous here. You have to really do your research to understand what this is about. This is the Secretary of Puerto Rico, okay? Secretary of Treasury of Puerto Rico. Upon notice to the Secretary of Treasury of Puerto Rico that any person is acting for another person in a fiduciary capacity. What are they talking about here? This is Form 56. If they don't have Form 56 on record with the Secretary of Treasury of Puerto Rico, they're in violation. They can go to prison for that. Okay, they're not authorized to touch decedent estate property without your express written consent and without a delegation of authority, power of attorney, letter of appointment, or Rule 2 opinion letter from the Secretary of Treasury of Puerto Rico. All right, saying that they can. Such fiduciary shall assume the powers, rights, duties, and privileges of such other person in respect of a tax imposed by this title. Remember how I told you all these courts, they're not telling you the true nature and cause of the transaction. All right, they're administering a Chapter 11 bankruptcy. They're hypothecating credit into existence. And because they don't have permission from the Secretary of Treasury, they're engaged in money laundering, the trafficking of persons, the trafficking of humans, the trafficking of children. They're engaged in RICO. And the biggest thing is the tax evasion and the administering the estates without the expressed authorization from the Secretary of Treasury of Puerto Rico, wherein they've asked for permission on the Form 56 to be a fiduciary and an administrator or executor over the estate, okay? And because they haven't done that, they're engaged in usufruct. And they're engaged in looting, pandering, stealing, and lining their pocket, except as otherwise specifically provided in the and except that the tax shall be collected from the estate of such person, okay? Remember, a person is a corporation, a trust, a joint business venture. That's a person. And it's an estate of such person, right? Okay? That estate is a United States juristic person until notice is given that the fiduciary capacity has terminated. Manner of notice. Notice under this section shall be given accordingly with regulations prescribed by the Secretary of the Treasury. The Secretary of the Treasury of Puerto Rico says you need to fill out a Form 56 if you're going to administer anybody's estate. All right? So that's under Title 26, 6903. Next. Before they touch decedent estate property under Title 26, 2032 AE 11, they are required. This is anybody touching decedent estate property. Bond in lieu of personal liability. If the qualified heir makes written application to the Secretary of Treasury of Puerto Rico for determination of the maximum amount of the additional taxes which may be imposed by subsection C with respect to the qualified heir's interest, the Secretary of Treasury of Puerto Rico, as soon as possible and in any event within 1 year after the making of such application, shall notify the heir of such maximum amount, the qualified heir, on furnishing a bond in the amount and for such period as may be required, shall be discharged from personal liability for any additional tax imposed by subsection C and shall be entitled to a receipt or writing showing such discharge. Again, before they touch your decedent estate property, okay, they are supposed to be independently bonded with the Secretary of Treasury of Puerto Rico. And to ensure that they are compliant in doing this, we need to report them on a Form 56 and send it off. All right, so this is just another way of holding their feet to the fire. So this is Title 26, 2032 AE 11. They're required to be independently bonded by the Secretary of Treasury of Puerto Rico. Under Title 26, 6903, they're required to have a delegation of authority, warrant of attorney, letter of appointment, grant of assignment to even touch decedent estate property. What's decedent estate property? The all caps name, the Social Security account number, things of that nature, right? All right. Under Title 26, United States Code 6036, all other trustees and fiduciaries, right? This means the city council, the county board, the sheriff, the whoever else is out there holding an office of trust or being a trustee or office of honor and for profit, right? Title 26, United States Code 6036, Notice of Qualification as Executor or Receiver. Every receiver, trustee in a case under Title 11 of the United States Code, assignee for benefits of creditors or other like fiduciaries, and every executor as defined in sections 2203 shall give notice of his qualifications as such to the Secretary of Treasury of Puerto Rico in such manner and at such time as may be required by regulations of the Secretary of Treasury of Puerto Rico. The Secretary of Treasury of Puerto Rico may, by regulations, provide such exemptions from the requirements of this section as the Secretary deems proper. But before he can make that evaluation, they would first have to put him on notice with a Form 56. Okay, but they're not doing the Form 56s, ladies and gentlemen, and that's where we have a duty to report them. And how are we going to report them? We're going to report them on a Form 56. We're going to do a 3949A, a 211 form, a 13909, a 4506A. We're going to do a Form 56, and we're going to report them. Title 26, United States Code, subsection 7603, before the summons can even be issued by a ministerial administrator administrating estates and administering a Chapter 11 bankruptcy. Ladies and gentlemen, they have to have the express written consent, delegation of authority, letter of appointment, grant of assignment from the Secretary of Treasury of Puerto Rico to even issue a fucking summons pertaining to your estate. Okay? That's Title 26, United States Code 7603. They didn't have that permission from the Secretary of Treasury of Puerto Rico before they issued a summons. They're in trouble. All right? Shall be served by the Secretary of Treasury of Puerto Rico by an attested copy delivered in hand to the person to whom it is directed or left at his last and usual place of abode. And the certificate of service signed by the person serving the summons shall be evidence of the fact it states on the hearing of an application for the enforcement of the summons when the summons requires the production of books, papers, records, or other data. It shall be sufficient if such books, papers, records, or other data are described with reasonable certainty. Again, who's got to approve this? The Secretary of Treasury of Puerto Rico, ladies and gentlemen. Before they can demand any of this shit from you, they had to be in compliance with the Secretary of Treasury of Puerto Rico. Why? Because they're administering an estate. It doesn't have anything to fucking do with you, the living man or woman. It has everything to do with the estate, your inheritance, as an heir, as a benefactor, as a sestiquii, all right? Having sestique use of this estate. They're robbing, raping, pillaging. They're taking from you. Under Title 26, United States Code 2603, liability for tax. Remember, I told you all their little courts are nothing more than tax courts. Right here, number 2, taxable determination. In the case of taxable determination or a direct skip from a trust, remember, they're creating a constructive trust in their venues, okay? The tax shall be paid by the who? Trustee. The fiduciary trustee is responsible for paying everything, okay? All debts are obligations of the United States, period. All right? They're responsible for the taxes and paying the taxes. All right? Under Title 26, United States Code, subsection 201. This is where I always go off in my little tailspin where I talk about Title 26, 2603, 2602, 2001, and 2002. Now you might understand what I'm actually talking about. Okay, Title 26, United States Code, 2001, imposition and rate of tax. Wait. I got to go back one. Okay, so we did Title 26, United States Code 2603, liability for tax, right? And we show who's liable for the taxes, the trustee. Okay, they hypothecated your credit into existence. They're in constructive possession of decedent estate property. They're liable for the transfer taxes on a carryover basis. All right, we don't know how much they hypothecated your estate's value into existence, but they're still liable for those funds. Now, Title 26, 2603, 2602. 2602 is Title 26, United States Code 2602, amount of taxes. The amount of the tax imposed in Section 2601 is the taxable amount determined under Subchapter C multiplied by the application rate determined under Subpart E. Okay? So under Title 26, 2603, 2602, 2001, and 2002, anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis. Okay? So, on Title 26, United States Code, subsection 2001, imposition and rate of taxes, a tax is hereby imposed on the transfer of a taxable estate of every decedent who is a citizen or resident of the United States. Your decedent estate is a resident of the United States. It is a creation of the United States. Okay? And that's why there's a taxable termination. All right? Computation of the tax imposed by this section shall be the amount equal to the excess, if any, of a tentative tax computed under subsection C of the sum of the amount of the taxable estate and the amount of the adjusted taxable gifts. Because remember, they're whisking away your credit, saying, "Oh, he gifted it to us." So how does a class tax 5 become a class tax 2? All right, over the aggregate amount of tax which would have been payable under Chapter 12 with respect to gifts made by the decedent after December 31st, 1976, if the modification described in subsection G had been applicable at the time of such gift. For the purpose of paragraph 1B, the term adjusted taxable gifts means the total amount of the taxable gift within the meaning of section 2503 made by the decedent and December 31st, 1976, other than gifts which are includable in the gross estate of the decedent. All right, so there's 26 United States Code, subsection 2001, imposition and rate of tax. And then we go to my favorite part, Title 26 United States Code 2002, liability for payment. Tax imposed by this chapter shall be paid by the executor fiduciary trustee. That's why the judge is always trying to get you to come in and claim the fucking name. They're trying to get you to fill the role of fiduciary trustee, the executor, the one who's liable. All right? So, then we go to Article 6. All debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution as under the Confederation. What we just went through on Title 26, that's all dealing with the IRS. That's going to be your 4506A, your 13909, your 3949A, and your 211 form. That's going to be your Form 56, and it's going to be your IRS identity theft form, because they're stealing your identity. All right? Under Title 26, United States Code 7201 through 7217 are going to be all of the ramifications and consequences for what they are doing. Okay, so you need to report this to the IRS on a Form 56, 4506A, 13909, 3949A, and a 211 form is a whistleblower form that will get you paid. All right? IRS Form 2373, 10492, 4490, 4810, IRS Form 1099R, 1099F, 1099 Miscellaneous, and a 2848 are all the forms that judge, ministerial administrator, administrative law clerk, and administrative law judge are supposed to have on file to handle decedent estate property. Okay? You need to report their fucking asses. That's separate from the impeachment, which we're going to talk about now, is the impeachment. All right? I go after them in a multitude of ways. I just don't go after them in one aspect of things. I'm multifaceted. And I operate in multiple jurisdictions simultaneously, and I put their fucking nuts in a proverbial vice, and I fucking squeeze, because I can, for the same reason a dog licks his testicles, because he fucking can, all right? 15 years of doing this shit, I do things very cold, very calculated, and for purpose and good reason. Why are we talking about Article 6 of the Constitution? Because I want to point out to you that the original jurisdiction of the judiciary is still there. Let us now return to the partition of the judiciary authority between different courts and their relation to each other. The judicial power of the United States is, by the plan of the convention, to be vested in one Supreme Court. Okay? All the other inferior courts are military tribunals. We don't belong in there. That's not our venue. Our venue is the one Supreme Court, a court of competent jurisdiction and a court of record. All right? Unless we're being indicted, we don't belong in their venues. We're going to immediately tell them to cease and desist. We're going to demand that they prove up that they have the proper oath of office on record, that they have the proper certificate from the notary with the proper Jurat statement on it and the anti-bribery statement and the proper bond. We're going to demand all this shit, and we're going to tell them, look, you're going to cease and fucking desist or I'm going to throw you in prison, okay, for violating the Constitution, engaging in mixed war, hypothecating the credit of the estate without the expressed authorization of the Secretary of Treasury of Puerto Rico, money laundering, human trafficking, trafficking of persons, all right? We're going to nail your nuts to the wall, okay? So cease and desist, or my next move will be grounds for the impeachment. Let's go into talking about the impeachment. In order to understand the impeachment, we have to understand the Constitution. The Constitution of the United States of America, 1787. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain. Only God can ordain. Do ordain and establish this Constitution for the United States of America. Okay? So it's for our purposes. It's for we the people. Okay? We the people. Article 1, Section 1. All legislative power herein granted shall be vested in Congress of the United States, which shall consist of a Senate and a House of Representatives. That's important to understand. Section 2. So Article 1, Section 2, Part 2. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States. Okay? Citizen of the United States is not a non-resident alien of the Union of States. The United States is a 10 square mile jurisdiction. You had to participate, be of the age of 25 and been participating in the United States to hold that office, okay? Which means that you've taken an oath and you are foreign to we the people, all right? With a fiduciary duty as a trustee to we the people, to uphold, defend, protect, and ensure that our Republican form of government is never being overthrown by overzealous communist halfwits. 5, the House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment. The House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment. That's what we're talking about now. We're going to impeach the judges. We're going to get rid of their asses. All right? The Senate shall have the sole power to try all impeachments. When sitting for the purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in the case of impeachment shall not extend further than to the removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. All right? So once they're impeached, they no longer can cause harm, damage, loss, or hardship to our fellow brothers and sisters, which is fantastic. And now we have the ability to have the Attorney General go ahead and prosecute them. And if the Attorney General won't prosecute them, we can come in as private attorney generals and we can prosecute them qua tam. All right? And it's our duty to do so. Okay? Section 8. Okay, Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excise, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excise shall be uniform throughout the United States. Okay, the United States is 10 square mile area, ladies and gentlemen. Everything they're talking about. The Congress has the ability to lay impost tax, excise tax, duties tax, tonnage tax, all that stuff is in a 10 square mile area of Washington, D.C. When I told you guys that the federal government has a very limited amount of authority, I mean it is very, very fucking limited. All right? But you really have to read to comprehend, not just read to read the words. All right? Impost and excise shall be uniform throughout the United States. To borrow money on the credit of the United States, okay, so we're the creditors of the United States, and they're borrowing money or credit on the United States. To regulate commerce with the foreign nations and among the several states and with Indian tribes. To establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof and of foreign coin, and fix the standards of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States. Okay, so what does Congress have the power to do? Who should be reporting to when they are engaged in counterfeiting? We should be reporting to the Congress. More specifically, when we're reporting, we need to be reporting to the Senate, who shall have the sole power to try all impeachments. Okay? We need to be reporting to the Senate. The House of Representatives shall choose the Speaker and other officers and shall have the sole power of impeachment. The House of Representatives and the Senate. Okay? That's who we need to be reporting to. All right, to establish the post office and post roads, to promote the progress of science and the useful arts and the securing of the limited times to authors and inventors of the exclusive rights to their respective writings and discoveries, to constitute tribunals inferior to the Supreme Court. When they're talking about to institute tribunals inferior to the Supreme Court, these are the lower Article 1, Section 8 military tribunals that you and I do not belong in, okay? This is the administrative law judges and the administrative law clerks and the Administrative Procedures Act and all that fancy fucking gobbledygook that we have no business in dealing with. To define and punish piracy, all right? So Congress, okay, again, when we go to impeach them, what are we impeaching them on? The grounds of piracy, right? And counterfeiting, okay? And Congress has the ability to punish, right? Through the Senate and the House of Representatives, okay? So, to define piracy and felonies committed on the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on the land and water. To raise and support armies, but no appropriations of money to that use shall be for a longer term than 2 years. To provide and maintain a navy, to make rules for the government and regulations of the land and naval forces. To provide for the calling for the militia. So we've got a regulated militia and then we have the unregulated militia. Okay? Just like we have enumerated rights and we have the unenumerated rights. We have the enumerated law and then there's the unenumerated law. To execute the laws of the Union. Okay? Of the Union. Suppress insurrection and repel invasion. To provide for the organization, aiming, and discipling the militia, and for the governing such part of them as may be employed in the services of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline, prescribed by Congress. To exercise exclusive jurisdiction in all cases whatsoever over such District of Columbia, not exceeding 10 square miles. Okay, that's Article 1, Section 8, Clause 17. That's their venue. All right? They're telling you the very limited jurisdiction they have, as may by sessions of particular statutes, of particular states, and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislator. So they only have jurisdiction over the things they've purchased by consent of the legislator, the 10 square mile area, military arsenals, forts, and buildings, and lands that they have acquired or purchased of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. Again, their jurisdiction is what? 10 square mile area. The land that they've been authorized to purchase through the legislator, their military forts, arsenals, dry docks, and buildings. Okay, that's it. That's to the extent of their jurisdiction, ladies and gentlemen. Period. Okay? And when they usurp that by having agents and agency draw you into a foreign jurisdiction under statutes, codes, city ordinances, rules, and regulations, which are legislative edicts, bills of paying that do not apply to you, it is your duty to impeach them because they are engaging in mixed war against the de jure form of government, the Republican form of government that you were guaranteed, the Republic form of government. Okay, the Republic. All right? And that's what they're doing. They're ensnaring you in an artifice and a scheme, trying to make you subject to their jurisdiction so they can hypothecate your credit worthiness and your credit into existence and whisk it away and steal it from you under an artifice and a scheme using a false conveyance of language, simulated legal process using sham legal pleadings that are unsworn to, unverifiable, violating the 6th Amendment, the 4th Amendment, the 5th Amendment, the fucking 3rd Amendment, the 1st Amendment, the 8th Amendment, the 9th Amendment, the 10th Amendment. All right? And violating the 7th Amendment. Section 9. Clause 8. No title of nobility shall be granted by the United States, and no person holding any office or profit or trust under them shall, without the consent of the Congress, accept of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. Ladies and gentlemen, the American Bar Association is a foreign principle, foreign state. Titles of nobility. Okay, they call themselves esquires, they call themselves attorneys, they call themselves squire, they have these titles of nobility. These people are working for a foreign principal are not supposed to be sitting in the office or filling the seat of office of government, period. And it's right there. Section 9, Clause 8 of Article 1. Okay? Then Section 10, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold or silver, coin a tender in payment of a debt, pass any bills of attainder, ex post facto laws, or law impairing the obligation of contracts, or grant any titles of nobility. The states are engaged in all of this. The state of Nebraska, the state of New Mexico, the state of Arizona, they're all engaged in this. They've created titles of nobility. They've created ex post facto law. They're trying to drag you into a foreign jurisdiction, which is mixed war against the Constitution. They're overthrowing our constitutionally guaranteed republic form of government by usurping power otherwise not delegated to them in usufruct. And the only way to stop it is for we, the American people, to stand up and say, enough's enough. We're going to impeach your dumbasses. You're taking your income under false pretenses. That's theft by way of honest services fraud. Okay? Unjustly enriching yourself. And now it's our duty and our pleasure to put you back in your place. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court. That was also conferred in the Federalist Papers, number 81. Okay? and in such inferior courts as the Congress may from time to time ordain and establish. Okay? Now, in this section where they're talking about the inferior courts, that doesn't apply to us. Those are those military tribunals that you don't belong in. Okay? Judges both ordain and establish. The judges, both of the supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their service a compensation which shall not be diminished during their continuance in office. They're already getting paid. They're fiduciary trustees. They're supposed to be protecting our unalienable rights, not allowing these shitbags known as bar attorneys to fleece and extort the American people. Section 2, with simulated legal processes using sham pleadings. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Again, just pointing out the fact of what actually constitutes the law. We've got the treaties, we've got the Constitution, we've got the constitutions of the several states. Those are the laws. You got the Federalist Papers, you got the Anti-Federalist Papers, the treaties, the Charter of the Forest, the Treaty of Peace, so on and so forth. Those are the law. Not statutes, codes, city ordinances, rules, and regulations. What does Article 3 tell you the law is? Article 3 is pretty fucking clear. All right? So Article 3, Section 3, the trial of all crimes except in a case of impeachment. Well, who's responsible for impeachment? The House of Representatives and the Senate, right? Shall be by jury, and such trial shall be had in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at the such place or places as the Congress may by law have directed. Section 3, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in an open court. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Article 4, Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2. The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. All right? A person charged in any state with treason, which is a felony, or other crime, who shall flee from justice and be found in another state, shall on demand of the executive authority of the state from which he fled be delivered up to be removed to the state having jurisdiction of the crime. In other words, the citizens of each state shall be entitled to the privileges and immunities of citizens of the several states. We have the right to hold these people accountable by indicting them, all right? And we have the full faith and credit behind us in doing so. And Article 6, Section 1, very firmly affirms, or very acutely affirms the fact that the treaties and laws made pursuant to the Constitution have the full force, weight, and effect, which means the organic judiciary is still there, even though they try to tell us there's no such thing as an Article 3, Subsection 2, Subpart 1 venue. All right? Section 4 of Article 4. Section 4, the United States shall guarantee to every state in the Union a republican form of government. This is a guarantee, ladies and gentlemen, and shall protect each of them against invasion and on application of the legislator or of the executive when the legislator cannot be convened against domestic violence, and domestic violence is domestic terrorism. That's what these people are engaged in. These foreign actors operating on behalf of a foreign principal are engaged in domestic violence, which is domestic terrorism, okay? And this is where Article 1, Section 8, Clause 17, the territorial jurisdiction comes into play. Because we can contact them and say, hey, come get your rogue dogs. Come get your rogue agents. They're pissing all over my white wall tires. I'm not very happy. Come scoop them up. Come remove them. Educate them or throw them in Leavenworth. Throw them in Guantanamo Bay. All right, I'm not opposed to public hangings by any means, especially at this point. All right? They're hell-bent on destroying our way of life and making people fucking miserable. And they've done a pretty good job of it. I think it's time we fucking return the favor. But it's not out of animosity. It's just because it's our fucking duty. It's our duty to do so. Okay? So it's not malicious, and it's not animosity. It's our duty. We're duty-bound to make sure they meet a shortfall with a sudden stop. And we can all cheers at the end. All right? After all, they did it to themselves. Article 6, all debts, contracted, and engagements, which is another word for contracts or agreements, entered into before the adoption of the Constitution shall be as valid against the United States under the Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. Did you notice they didn't say any statutes, codes, city ordinances, rules, and regulations will be the law of the land? No. They said the treaties and the laws thereof shall be the supreme law of the land. And the judges in every state shall be bound thereby. So the second that they abscond from the Constitution, from the treaties, and they rule against you using some benign statute, code, city ordinance, rule, or regulation, they're engaged in mixed war and treason. And you have a duty to report it to the House of Representatives and the Senate, okay? And this is how we're going to clean up house. To the contrary, notwithstanding, the Senate and representatives before mentioned and the members of the several states, legislators, and all executives and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support the Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. All right? How are we going to charge them up? How are we going to indict them? How are we going to impeach them? Well, Articles 1 through 10 is a good place to start. But in order to use them, you have to understand them. Article 1, Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peacefully assemble and to petition the government for the redress of grievance. So if the Congress can't do that, nobody else can do that. Not the judiciary, not the executive branch, not the administrative law clerks, not the administrative law judges. They cannot stop you from your petition to the government for a redress of grievance in the form of a fucking impeachment. All right? Article 2. A well-regulated militia, which means if they're talking about a well-regulated militia, there must be a well-unregulated militia as well, because you can't have one without the other, being necessary to the security of a free state. A free state. Part of being part of the unregulated militia is having the frame of mind and comprehension that you have to study to show thyself approved. That freedom isn't free. It requires you to remain vigilant at all times. It's not so much about bearing the arms and guns, guts, and glory, but actually on the intellectual spectrum, it's about ascending of the mind and learning the law so you can hold these public shitbags accountable. Okay? Which is far better than guns, guts, and glory. Don't get me wrong, there's a time and a place for that too. However, if we can do it without violence, that would be even better, right? Everybody gets to go home except for the ones that meet the shortfall with a sudden stop. And we're okay with that because they made a conscious decision to fuck the American people. The right of the people to keep and bear arms shall not be infringed at all under any statute, code, city ordinance, rule, or regulation, under any ATF or any organization that was not authorized by we the people to even exist, that the Congress didn't authorize to exist. By the way, the Congress doesn't have the power to delegate the power that we delegated to Congress. Think about that for a minute. If they don't have the power to delegate the power that we delegated to them in the first instance, how in the fuck could they possibly delegate power that we never even delegated to them in the first instance to another organization like the ATF, FBI, CIA, NSA, FDA? All of these are private, for-profit, federal-like entities that I won't even say they're federal, but they're federal in character, by name maybe, or association. But they were never authorized by we the people to create these entities. So these are foreign principles on our land, creating policies and procedures that they're using the administrative law judges and administrative law clerks to try and somehow bind us to their bullshit. All right? Treating you as a serf, a subject, claiming that somehow they have authority over you and that you have to abide by their statutes, codes, city ordinances, rules and regulations, or provisions or policies of their corporate charter. All right? But the FBI doesn't have a corporate charter. They were never authorized by Congress to even exist. All right? Nor does the CIA, the NSA, the ATF, the DEA, the FDA. None of them are authorized to exist. All right? Article 3, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Again, your automobile is an extension of your house. When they pull you over on the side of the road, the reason that they ask you if they can search your automobile is because the automobile is an extension of your house, and therefore you have a right to the expectation of privacy in your private household consumer goods that are used for household purposes and no other purposes are authorized, and therefore it's an extension of your home. And that's why they need a warrant to enter into your automobile, because it is considered, pursuant to the Constitution, as an extension of your home. Article 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized with great specificity. All right? So when they pull you over on the side of the road as motor vehicle code enforcement officers, understand this. They violated the Fourth Amendment. They violated the First Amendment. They violated the Third Amendment. Okay? They're operating arbitrarily and capriciously. They're in violation of their oath. They're engaged in mixed war, sedition, insurrectionist behavior, and treason. They don't have an APB out for you. They don't have a warrant out for your arrest. There's no federal grand jury that has indicted you and a true bill due and owing by a grand jury has been executed. Okay? So they're arbitrary and capriciously trying to usurp power otherwise not delegated to them and drag you into a foreign military jurisdiction, Article 1, Section 8, Clause 17, a territorial jurisdiction for which they do not have the ability to do. They're engaged in piracy on your land, a violation of Title 18, 1661. All right? Counterfeiting, conspiracy against rights, deprivation of rights, human trafficking, trafficking of persons, false arrest, false imprisonment, declaring an emergency when there is none. Okay? And therefore, you need to impeach them. Article 5. No person shall be held to answer for a capital crime or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any circumstance, case, to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Everybody says, well, the 14th Amendment is where you get your due process of law clause. Bullshit. It's the 5th Amendment. The 4th Amendment ain't worth a broke dick. All right? Nor shall private property be taken for public use without just compensation. When's the last time you've been paid when they took your private property and took it to impound? Huh? Yeah. When they just took your property and didn't cut you a check? Guess what? That's a violation. And you're going to report it as a Article 5 violation. Compounded with an Article 4 violation. We're going to move to impeach them. They're not fit for office, ladies and gentlemen. They're dumber than a fucking... I'll digress. These people are highly unintelligent. And some of them are very intelligent, but very unlearned and unwilling to understand exactly what their oath is and exactly what they pledged and vowed to execute as trustees and fiduciaries. And they're 100% liable for their ignorance. Because remember, when they took that oath, now they're knowingly, willingly, and intentionally violating their oath, which is the law of the land. That's their oath, to uphold the law of the land. So ignorance excuses no one, especially the one who made oath. Okay? So if they didn't go read this stuff, they don't understand it, and they're taking directives from attorneys who are hell-bent on overthrowing the Republican form of government and the foundational documents that have been set forth to preserve our life, liberty, pursuit of happiness, and the enjoyment of fucking property, ladies and gentlemen. That's on them. Because enough of us have been sounding the alarm for years. I don't feel bad at all if they get strung up. I don't feel bad at all if they end up in Leavenworth. I won't shed a tear if they find themselves in a position for a shortfall and a sudden stop. You wouldn't believe how many servicemen and women I know, when I ask them, have you ever read the Constitution? They go, no. Have you ever been given an educational course on the Constitution? They say, no. How in the fuck do you protect and defend and uphold the founding documentation and preserve the people's rights to a guaranteed form of Republican form of government if you've never read the documents in your fucking life? You realize by them admitting that they've never read the Constitution, they're taking their income under false pretenses, and that in and of itself is a jailable offense. They made false oath. They made false promise. That's a False Claims Act. Okay? Article 6. In all criminal prosecution, the accused shall enjoy the right to a speedy trial and public trial by an impartial jury of a state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusations, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Now, when they take you into the Article 1, Section 8, Clause 17, military fucking tribunals that are only supposed to be in a 10 square mile area, all right, when they're usurping power otherwise not delegated to them, having their gun-toting morons come out and accost you against your will, which is piracy on the land, and suck you into statutes, codes, city ordinances, rules, and regulations, and try and persecute you and make you liable for the credit that they're hypothecating in your good name without your knowledge, okay, and trying to make you the liable trustee or fiduciary or surety for the new debt they just created out of thin air. They're violating you, and they're violating the Sixth Amendment because you have your right to face the accuser. The state you can never talk to. The state you can't cross-examine. You can't call the state. You can't date the state. You can't fuck the state. You can't say hey to the state. You can't take the state out to dinner, and the state can't take you out to dinner, all right? This is their figment of their imagination where they are taking you into a fictional realm and fleecing you because you know not better. You know no better. And therefore, you subject yourself to it. Right away, that's grounds for fucking impeachment. Simulated legal process, false claim, false oath, false swearing, Sixth Amendment violation, Fourth Amendment violation, Fifth Amendment violation. All right? And you're going to move to impeach him right away. Steadfast. Article 7. In a suit at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Article 7, ladies and gentlemen, when they're taking you into these Article 1, Section 8, Clause 17, private military tribunals with foreign law into a foreign jurisdiction and they trespass on our land to come and snatch you up and bring you into their foreign jurisdiction, not only is it counterfeiting, not only is it piracy on the land, not only is it extortion, false arrest, false imprisonment, false impersonation, okay? They're also engaged in RICO. And because you're denied a protected right under Article 7, the right to a trial by way of jury at the common law. Remember, Article 6 said that everything prior to the Constitution, as far as treaties and agreements, would be honored, which means the original judiciary still exists, ladies and gentlemen. The rules of the common law. When you're being denied a trial by way of jury, you're being denied one of your unalienable rights. And therefore, it's grounds for impeachment. Impeach the prosecutor, impeach the clerk of the court, impeach the judge, send their fucking fat asses to Guantanamo. It's time. There's never been a better time than today to send these sons of bitches to Guantanamo. Article 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. When they're dragging you into a foreign military jurisdiction outside the territorial jurisdiction that they're authorized to operate in, which is military forts, magazines, arsenals, and buildings they own and lands that they have been authorized to acquire, which isn't much. When you talk about territorial jurisdiction, ain't much. When they're out on our public freeways, highways, byways, and passages, they are pirates on our land, engaged in privateering, unjustly enriching their principal, which masquerades around as government, but really is not de jure, but de facto. They owe us a fealty and a duty, and they're taking advantage of it. And it's time to put their dicks in the dirt. When they put you in a cage, absent a victim, absent a crime, and tell you got to sign these negotiable instruments or we're not going to let you go. That's cruel and unusual punishment. You're going to impeach the fuck out of those people. If it's a sheriff that's doing it, goodbye. If it's the clerk of the court that's facilitating it, goodbye. If it's a judge facilitating it and aiding and abetting, goodbye. Every agent and agency that falsely arrested you, falsely imprisoned you, and held you against your will and took fingerprints and photographs prior to taking you to the magistrate is violated their oath of office, and we need to say it with me, goodbye. Good riddance. Fuck off. You're gone. Guantanamo. And start passing out shirts that say Guantanamo on them. Article 10. Article 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So you have the enumerated rights and the unenumerated rights. You have the general tangible rights, and you have the general intangible rights. You have the general law, and then you have the unwritten law. And it's retained by we the people. Okay? What's that mean? You have the right to reform and abolish your form of government anytime you see fit. When they become tyrannical, you can fire their happy asses, or you can send them option B, Guantanamo. Article 10. The power is not delegated to the United States by the Constitution nor prohibited by it to the states, are reserved to the states, respectively, or to the people. See, they always forget about these last four words, or to the people. That which is not delegated to the federal government and the state government is, in fact, reserved to we the people, period. And they have very limited power at the state and federal level, ladies and gentlemen. They have usurped a fuck ton. Article 13, neither slavery nor involuntary servitude except as a punishment for crimes whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. Section 2, Congress shall have the power to enforce this article by appropriate legislation. Again, having you in a cage, held against your will with no victim, no crime, no affidavit in support of any claim being made by a man or woman is cruel and unusual punishment under the 8th Amendment and constitutes slavery, peonage, bondage, and involuntary servitude. All right? And is, again, grounds for what? Impeachment. But Article 13 isn't really that great compared to the Treaty of Ghent, which superseded Article 13. So I like to use the Treaty of Ghent. If you use the Constitution to impeach these people, it'll be fast. This is the 14th Amendment. I put it in red because this is a political fuckfest right here. The Supreme Court doesn't want to make issue with it because they say it's political, even though the Supreme Court was put into place just for this purpose because it wasn't properly ratified. The Supreme Court's supposed to come in and say, look, this was done under military occupation. It wasn't done properly. It wasn't done pursuant to the Constitution. 3/4 of the states did not fucking agree to it, and therefore it couldn't have possibly been ratified. But instead of doing that, the Supreme Court did what? They sat on their thumb, right up their ass, and said, you know what? That's a political issue, not a constitutional issue. And every time it's ever been made a constitutional issue by the way that they went about enacting, allegedly, the 14th Amendment, the judiciary always says, no, that's a political issue. Why don't they want to touch this? Because this is the gateway to slaves. This is the gateway to usurping power otherwise not delegated to them. That's why I don't use the 14th Amendment. Typically, I just use 1 through 10. The only reason I brought up 13 is because it's in harmony with the Treaty of Ghent to a degree, and it exemplifies the fact that cruel and unusual punishment shall not be had, because you're not supposed to be in a cage or submitted into involuntary servitude, peonage, bondage, or slavery until you've been convicted. Convicted! Just so we're all clear here, Constitution and military tribunals. The United States Constitution provides the foundation for military tribunals, which play a role in maintaining military discipline and addressing offenses during war or national security concerns. Understanding the constitutional provisions, historical context, and the roles of Congress and the President is important for appreciating how military justice is administered with our constitutional republic. I like how the military calls it a constitutional republic, don't you? I like that. Constitutional provisions for military tribunals. The Constitution grants specific powers related to military tribunals. Article 1, Section 8 authorizes Congress to establish tribunals inferior to the Supreme Court, including military tribunals. Article 2, Section 2 designates the President as Commander-in-Chief, providing a basis for military tribunal use. Article 3, Section 1 establishes judicial power, distinguishing civilian courts from military courts. The Fifth Amendment provides an exception for military matters, allowing actions without grand jury indictments in specific cases. These provisions balance power between branches, ensuring military tribunals operate within a legal framework while addressing unique military justice needs. The structure reflects the framers' intent to provide a national defense system that maintains order within the armed forces without overstepping constitutional boundaries. All right? And as you can see, there's Justice Gorchak, whatever his fucking name is. Anyway, how are we going to impeach them? Well, first you're going to go to your state revised statutes and you're going to look for the impeachment procedures. So you can impeach them at the state level, and then you can come over here and you're going to use the AO91 and you're going to submit this to the Attorney General. Okay, and so you put all your codes, amendment violation, First Amendment, Fourth Amendment, Fifth Amendment, Seventh Amendment, Eighth Amendment, Sixth Amendment, whatever it is. You can include piracy on the land, trafficking of persons, kidnapping, assault, battery, you name it, whatever you can fit in there, and attach all your evidence to this form, okay, when you submit it. Then we have what is called the DA 2823. This is a military form. This is a sworn affidavit. Well, Derek, how are you going to use the military form? Because I just expressed to you that they're using military jurisdiction. Article 1, Section 8, Clause 17, territorial and federal enclaves of military jurisdiction. Okay? And so we're going to return the fucking favor. And that way we can court-martial these shit dicks. This is why they end up going to Guantanamo Bay, because they're actually part of the military. So it's pretty simple. The DA 2823, you go through, you fill it all out. When you read the instructions, it tells you that you can submit this to any officer, any judge, any clerk of the court, anywhere in the United States, and they will send it up the proper chain of command. So you just fill out all the details and all the pertinent, intimate information, and it's nice because it goes and coincides with the AO91, and this is the DA, Department of Army 2823. Now, who are you going to report to? This is my favorite little website right here. Council of the Inspector Generals on Integrity and Efficiency. And if you'll notice, it always says report waste, fraud, abuse, or retaliation. So, you got the Agency of International Development. That really won't pertain to this matter here. We'll scroll down a little bit. For identity theft purposes, we have the Board of Governors of the Federal Reserve System, Consumer Financial Protection Bureau. Okay, that's identity theft. Then we have the Consumer Product Safety Commission. So if you got product that's bogus, bunk, bad, Department of Commerce, Department of Defense, Department of Health and Human Services, Child Support. Hammer them on this one. Tell them you're going to send them a nice fat daddy fucking $40 million bill for fucking with you. Invoice. Department of Homeland Security. Okay, because remember, these people are foreigners, so we got to deport them. We got to get a hold of ISIS, or ICE, and we got to deport these fucking cretins. We got to send them over to their queen. Department of Justice. Department of State. Department of Interior. Department of the Treasury. Federal Communications Commission, you can report them on that if they're emailing you, calling you by way of phone, harassing, badgering, and intimidating you, trying to drag you into a foreign jurisdiction. We can report them to the Federal Deposit Insurance Corporation because everything they're doing is opening up accounts in our good name. The actual administrative law clerks and administrative law judges are just negotiating negotiable instruments. And so the accounts they open up in your good name are Federal Deposit Insurance Corporation insured and backed. So we can report it to the OIG for the FDIC. Federal Maritime Commission, you can report them there as well. They're operating in maritime law. Government Accountability Office, you can report them there as well. When you click on these, they open up. And then right up here in the right-hand corner, it says Report Waste, Fraud, and Abuse or Retaliation. You click on it. It opens up, asks you a series of questions, answer the questions as you go along. Make sure you have a pen and paper ready so you can write down anything that you need to write down. Here's Integrity Committee on Council of the Inspector Generals on Integrity and Efficiency. This is if the Attorney Generals aren't taking seriously what you're reporting to them. Legal Service Corporations, Library of Congress. Here is, that one doesn't matter. National Credit, that's not pertinent to what we're talking about. It is a matter of national security. You could do the National Security Agency. The NSA, actually, if it's dealing with cyber crimes, they're emailing you or whatever, got you subjected to their bullshit automated system in the internet, you can report that to the National Security Agency, the NSA. Office of Personnel Management, you can also report it there. Securities and Exchange Commission, because they're negotiating negotiable instruments without your knowledge. So they're unregistered securities. They have hypothecated into existence, and they're not properly reporting them. So you can report them to the SEC. Also, the SEC for identity theft. The SEC will turn you over to the FTC for identity theft purposes. You can also turn them over to the Social Security Administration for not having the SSA 89 on file. That's a $5,000 penalty for not having the SSA 89 and administering the Social Security account number. So you can turn them over to the Social Security Administration. Treasury Inspector General for Tax Administration. This is what we call TIGTA. These are your heavy hitters right here. You report everything to TIGTA. All right, that's why we went over Title 26, 2032, AE 11, Title 26, 2603, 2602, 2001, and 2002. Anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis. Under Title 26, 2032, AE 11, they're responsible for being independently bonded. Under Title 26, 6903, they need to have a letter of appointment, delegation of authority, power of attorney, grant of authority, or grant of assignment to even touch your estate. We already covered how they are fiduciary trustees, liable for the transfer tax and liable to pay the taxes. And so that's where the Treasury Inspector General for Tax Administration comes in and is one of your best friends. Not only are you going to impeach him, but you're going to get him sent to prison for tax evasion, money laundering, human trafficking, the trafficking of your juristic person in a state without your express authorized consent and without the express written approval exemplified by a Form 56 from the Secretary of Treasury of Puerto Rico. All right, under Title 26, 7603, 6036. All right, they have to have permission, and they're not following Title 26. And all bar association members, judges, the like, are absolutely bound by the IRM manual and Title 26 and the Internal Revenue Code. All right, so the Treasury Inspector General for Tax Administration is important. You're going to report them there. Watch, you click on it, it opens up, report fraud, waste, and abuse. You click on it, it opens up, and you're just going to follow the prompts, okay? Pretty simple. Pretty simple. Where are we at here? Let's close that one and go back on this one. And that's the Treasury Inspector General Tax Administration, otherwise known as TIGTA. I also like to report to the U.S. Capitol Police. The reason that I do that is because, remember, their jurisdiction is Article 1, Section 8, Clause 17. Well, that's the District of Columbia, a 10 square mile area. So all these cretins actually are subject to the U.S. Capitol Police and the, what do they call it, the Metropolitan Police of Washington, D.C. I like reporting those assholes there. U.S. International Development Finance, International Trade Commission. No, but the U.S. Postal Service, you bet your sweet ass. We report them to the United States Postal Service as well. Why? They're using false and fictitious, unregistered, unverified names. They're unverified agents and agency that are unregistered, unknown, and they're sending threatening correspondence via the mail, via telephonic communication, and via email. And therefore, it is the jurisdiction of the United States Postal Inspector General, and we go ahead and we report them on that as well. When it rains, it pours. Again, just a simple way of doing it. So I hope that helps you guys out, understand what we're talking about with grounds for impeachment, and you're impeaching them under Article 4, Section 2, and you're hammering them and sending this to the House of the Senate and House of Representatives and the DOJ, Criminal Investigation Division as well. So you're also going to send it over to the DOJ, the Department of Justice, okay? And so I hope I shared enough information with you to get you in the right frame of mind. They don't have the proper Title V 3331 oath of office. They don't have the Title V 3332 affidavit alonged to it. They're not compliant with Title V 3333. They don't have the anti-bribery statement. They don't have their state constitutional oath proper. We went through the Title IV 101 oath, which is the actual oath to the flag, the Republican form of government. Under Title 28, 455, we're going to disqualify them as being the fiduciaries and the trustees. They have a conflict of interest because they're foreign to us. When they took their oath of office, they're foreign, all right? And this is the notarial certificates that are supposed to be alleged to their oaths of office, okay? And any affidavit that they make after that is supposed to have a notarial certificate and be registered on and recorded on file. They're foreign under Title 8 U.S. Code 1481, loss of nationality because they pledged an oath. Okay. Under Title 22, United States Code 612, they're supposed to have a Rule 2 opinion letter from the IRS showing that they can operate outside the 10 square mile of Article 1, Section 8, Clause 17. Where's their delegation of authority, letter of appointment, grant of assignment, power of attorney for them to operate outside of Article 1, Section 8, Clause 17. They don't have it. They don't have it. All right? Just to prove to you, all the sigils and seals are registered up in Canada, so anybody using these sigils or seals is a foreign agent operating on behalf of a foreign principal. There's the Department of Defense. There's the state of Indiana. There's the District of Columbia. There's your United States Secret Service. There's the Sonic Eagle design for the United States Post Office. And, of course, we went through a whole litany and array of them over here through all 50 states. We went through the Union Calendar number 1078, House Report number 3123, and this was a report on the National Lawyers Guild, the legal bulwark of the Communist Party, and it was done by the Committee on Un-American Activities, U.S. House of Representatives. This is a 52-page document. We didn't go all the way through it. You guys can look that up online. We touched on Title 26, 6903, and 6903. This is Title 26, 2032 AE11. They're supposed to have a bond registered with the Secretary of Treasury of Puerto Rico before they even touch your estate, in case they cause you harm, damage, and loss, and a hardship. Under Title 26, 6036, anybody else that is dealing with your estate, again, is required to have the express written consent from the Secretary of Treasury of Puerto Rico. Under Title 26, United States Code 7603, before a summons can even be issued, the Secretary of Treasury of Puerto Rico has to authorize whoever is issuing the summons to go ahead and issue that summons, to compel any papers or whatever else that they want. Of course, they never do that, so you're going to report them, all right? Real simple shit. Then under Title 26, United States Code, subsection 2603, liability for the taxes. We've already told you that taxable termination, in the case of a taxable termination or direct skip from a trust, it's always a constructive trust they're creating in these military tribunals. The tax shall be paid by who? The trustee. And who's the fucking trustee? The guy sitting on the fucking bench. He's responsible for paying the taxes. Under Title 26, United States Code 2002, liability for the payment. The tax imposed by this chapter shall be paid by the executor fiduciary trustee. Okay? All right? Then we went into Article 6. We went into Federalist Paper 81, showing that the Supreme Court is still there, the true court of competent jurisdiction and court of record that we are entitled to. We went through the Constitution, showing you the legislative power and where we need to go in order to impeach. We need to go to the House of Representatives, and the Senate has the sole power to impeach, so that's what we're going to do. Showed you the Constitution and military tribunals in Article 1, Section 8, Article 2, Section 2, and Article 3, Section 1. We showed you the Nebraska revised statute, Nebraska State Constitution, Article 3, Section 17, which shows you how you impeach at the state level. I also would implore and encourage you to impeach at the congressional level as well, in case the shitbags at the lower level don't do their job. You got a backup plan. The AO 91 is what you're going to present to the Attorney General to bring suit, okay, for their violations, violating the Constitution and subjecting you to peonage, bondage, slavery, involuntary servitude, human trafficking, trafficking of persons, false arrest, false imprisonment, so on, so on, so on, and so on. All the names go here of the people that violated you, and you just fill it out. Of course, you want to pay attention to the jurisdiction that you're in. Each jurisdiction may be different. For example, it looks like you got Eastern District of Virginia, you got the District of Virginia Islands, you got Western District of Virginia, Eastern District of Washington, so on and so forth. So you need to go find that and make sure that you're proper in your assessment. Of course, you sign it and all that stuff, and you launch all your paperwork to it. You can also launch to the AO 91, the DA 2823, because Title 10 is in the military, and again, these are going to be military tribunals for these shitbags. All right, and last but not least, I ran you through the Council of the Inspector Generals on Integrity and Efficiency. This is all the Inspector Generals for the United States, including the Board of Governors of the Federal Reserve, Central Intelligence Agency, so on and so forth. Find what works for you and what is needed. When you click on these, for example, the Department of Defense, and right up at the right-hand corner, it says Report Waste, Fraud, Abuse, and Retaliation. You click on that, and then you go ahead and you answer all the little details that come up in order to finish this out. So, hope that helps you out. Let's send some fucking people to Guantanamo before Christmas, shall we?